Yes, my lord's kind leave to mention very urgent appeal, my lord. My junior had mentioned earlier. The matter was taken up subsequently, my lord, although it was not the returnable date. Matter was taken up yesterday. My lord, what happened in the court is unbelievable. My lord, I do not want to say all these in open court. My lord, would your lordship kindly take up this appeal on Monday with? Yes. We are also taking up, my lord, steps for the order that was passed yesterday to be appealed, my lord. Monday. Well, Monday, my lord. Yes. And I'll be troubling your lordship once more, my lord. Once my appeal is prepared from yesterday's order, my lord, I'll be seeking leave from your lordship, my lord, to file so that both can come. Leave granted for both. Grateful to you. I am grateful to you.
Lord,
Really permitted to mention one matter, certified without certified copy, my lord. But today's list, the petitioner has preferred the appeal, my lord.
Monday top lordship because lordship.
Yes.
My lord, today's list, the petitioner has preferred the appeal. We are for the department. We are also preferring the appeal.
What is the appeal item number?
Item number 19.
You be there when the matter is called.
Yes, I will, my lord. Leave may be granted. That matter can be taken up at the time.
Leave granted.
Lord,
may I have a
urgent PIL, Lord, today morning at around 10 a.m., Lord, the State Election Commission has published a notification, Lord, declaring the Panchayat election on 8th of July. Lord, today 10 a.m. the notification is published. From 11 a.m. the nomination starts. For 75,000 and odd seats, 6 days have been allocated, and all 6 days, 4 hours have been allocated. So 24 hours for 75,000 seats. Lord, I have calculated 39 seconds for one nomination, which has been given by the state. Number one. Number two, Lord, no all-party meeting held. Number three, all previous year's election. I have annexed all documents. Our Lord, I would not say it's any more apprehension. It's the reality in Bengal. Lord, the opposition parties would not be, Lord, allowed to file nomination. I would remind your lordships from the records, in 2018 election, people were, Lord, abducted from the nomination center. People were stabbed, bullet injury. They were, Lord, beaten when they went to file nomination. Lord,
you file it today.
Lord, I have to move it today, Lord, at 2 p.m. or any time, because today the nomination filing starts. 10 a.m. nomination notification.
Yes, for the election
Lord, Miss Sonal Sinha, I'll serve on her. I'll serve on the GP and come back.
My lord, similar prayer, my lord, we are also preferred public interest litigation, my lord. We are seeking leave before your lordship, my lord. We had.
He's also saying the same.
Leave can be.
She's hospitalized, so she has instructed me to take.
We'll serve on her.
No,
That's so nice of
her.
So nice of
you get instruction by around 12:30. We'll call the
12:30, my lord.
They say the time is inadequate.
Yes.
Any officer is there from the election commission?
Be served, and I will tell her.
So 12 o'clock we'll take it.
12 o'clock. Lord, kindly allow me to.
Yes, you give your copies.
Yes, Lord, I have to take the leave so that I can file.
My lord, leave.
You collect the
Short
copies.
service, I'll serve on
Ask
her.
some officer to come from the commission. Let him be here. And let you discuss with the chief election commissioner, saying that the prayer is inadequacy.
Lord, there are 3 more things then I should point out. We are praying that not CCTV to be installed in all booths, because there are orders not passed.
That already Election Commission of India has issued notification.
No, but State Election Commission would not abide by that.
That they will do.
Number 3, my lord, we have prayed in the writ petition that my lord, all nominations to be filed, my lord, in the central offices, because from the last time elections, my lord, experience, but I can show your lordship the document paper cutting that, my lord, there was injuries that I have said. That is the 3rd prayer. 4th prayer, Lord, deployment of paramilitary forces.
You come back.
Let her come back with all instructions.
You come back at 12.
My lord, I'm grateful to you.
May I have your lordship's kind leave to file an appeal without certified copy, lordship?
Your lordship, may I permit to mention a matter for inclusion in the list under the heading of motion. Your lordship, there is an urgency in this matter. This public interest litigation was filed for providing a compensation or an insurance to the voters who have who cast their vote in their elections. Now, the last year, the Panchayat elections in the year 2018, the voters who turned up the vote.
Now, it's a fresh matter, or
it is a fresh matter 2018, but never, due to business of the court, it is never called for any hearing. Your lordship,
2018 is not a fresh matter.
It is not, but never come for any hearing for any day, your lordship, due to business of the court.
You should have moved for it.
Your lordship, on several occasions, it is on the list, but your lordship.
No, you have given the slip now. We'll call for the file and we'll see what has happened, and then we'll list it.
Much obliged, your lordship.
First time I am arguing for your 3 months back. I have got a locker and Barajan room number 1. Most of the days I am being tortured by the learned members, some of the learned members. Yesterday, one thing has happened. I have narrated everything here, including me. I got forwarded copy to the register. She was kind enough to see this. And in Barajan secretary, he's out of town. My bag was kept away between my page. I have to run over to Hershey's police station. My tiffin box, my parts, and everything was there. Finally, it was found in the dustbin. Below the dustbin, I took a video of this, and I told,
Now, what is that you want?
please.
No, you file a petition.
Petition.
How we
I've
can,
written, sir. I've just written. Can go to then I'll file petition. I've
no.
just written.
see, if you want some relief,
Huh.
you have to move a matter.
Achha.
How we can, this is an internal dispute between yourself and some other advocates.
The internal dispute, sir, but the situation is going to the extent which is not possible for me to consume. So this is happening every day. Most of this is happening, sir. My lord, this is most of the happening.
Unless a petition is there, we can't do anything.
Fresh petition I have to submit. Sir.
No. Unless it is a writ petition or something else, we cannot entertain.
Achha. Yeah,
You think
whatever.
over it, you
whatever
discuss and come back.
Achha.
Yes.
May I have your lordship's kind leave, my lord, to mention, my lord, I have item number 27 of your yesterday's list, my lord. Contempt notice has been issued, my lord. So, my lord, if lordship can take it up on Wednesday or Thursday, my lord,
Yes,
because my learned friend is-
automatically it will come. Automatically it will come on Wednesday.
yes, some precedents because I have issued
No,
with
I
the
think
contempt notice.
that interest seniority will not be affected. Only fresh matters are to be added or some dismissed for
If
default.
it is, my lord, if it is a, because I have served with a contempt notice by my learned.
Yes, Wednesday.
Great.
Yes.
But I seek mentioning of that matter, my lord, which we mentioned on the Monday.
Hmm.
On that,
Yesterday we have granted leave.
my lord, now the another development which has happened is that now several petitioners themselves, my lord, have received this kind of letters.
Let the matter come up, we'll decide.
So, my lord, the urgency is, my lord, kindly see this second one.
Saraf, you move the matter on Monday. Leave has already been granted.
Monday, can it be listed, my lord?
Yes, why not? If it is already numbered, it will be listed. Fresh matters, we have already instructed. As soon as it is numbered, it has to be listed.
But my lord, kindly have a look
In
at.
the presentation form, you would have given a date, automatically it will come.
So that was given on Friday because it is relating to this tax.
It is a concept.
So I will give the mentioning slip to them.
No, this can't be listed. No, let the other matter come up. We'll issue comprehensive direction. We'll consider everything. If it is for the individual assessee, notices have been given, they have to respond. What was mentioned was the advocates are being harassed. That's why.
My lord, kindly just have a look at the kind of letters which are being given. Kindly have a look at the.
You challenge this also. Let the couple of dealers challenge this.
My lord, kindly have a look at this. By 12th, they are saying, my lord, and they are not issuing letter in all the cases. Yesterday, couple of writ petitioners were visited by the CID department in Malda, and they are threatening that why are you not making the payment of the tax? How does it matter that the writ petition is pending? In one of the matters, they are saying just because the penalty has been levied, why are you moving the writ petition?
We can hear that. This matter will come only on Wednesday. It is group 4. We'll have it on Monday. We'll have it on Monday, the other matter, which you have filed now. Leave to file Monday.
Yes, sir.
You give the number, it will be listed on.
Yes, sir.
Madam, may I permit to file this appeal without the certified copy?
Yes.
My lord, this is an extremely urgent matter that I would like to mention. I'm an LPG distributor, my lord, and the learned single judge has disposed of my writ petition directing me, that is the writ petitioner and the private respondent, to submit a joint application for renewal of my license. My lord, under the marketing and discipline
You
guidelines.
have filed the appeal,
My lord, yes. Filed.
you give the number, it will be listed. Yes.
My lord, with respect to determination in group 9, a serious problem has come up, my lord, because earlier in the cause list, my lord can recollect, there was mentioning of group 9, including police matter, including CBI and central agencies. Now, thereafter, one order was issued by the then Honorable Chief Justice on 30th September 2022, saying that the term police is already included, including CBI and other central agencies. At paragraph 3, my lord, will find.
No, this is a matter. Why do you mention it in open court? You give a representation to the secretary.
Very well, because I was asked to take instruction, clarification from your lordship, and PS was instructed.
No, whatever you want, you make it in a representation form,
Well,
and then I'll consider.
very well. Well, I was told that.
You do that, huh?
Well, very well.
Appellate
Should should I make the application through the register?
To the Registrar General or to the OSD to the Chief
My
Justice.
lord, so to your lordship.
Appellate side, daily list, serial number 1.
I appear on behalf of the appellant. May I file my affidavit of service?
What is the matter, sir?
Now, the matter is the petitioner, the appellant before your lordship. He was a contractor, government contractor, and he was awarded and previously successfully completed various projects of the government, different department. Now, lordship, in the present case, the work tender was invited. It's under Pradhan Mantri Gram Sadak Yojana. He was selected. He submitted the bid. He commenced constructional work just prior to the pandemic of COVID-19 intervened. On 17th of March 2020, the work order was issued, and within a week, the complete lockdown was started. Now, in terms of the tender, there is a time limit for completion of the work, 9 months. Now, lordship, as a result of complete lockdown, I could not complete the work within the time.
Correct.
There are provision in the tender document that if the contractor applies before the executive engineer seeking extension of time, on the grounds mentioned therein, the contractor will grant time for completion of the work. So in the present case, several applications were made, but they are for extension of time on the ground of COVID and thereafter due to various reasons not attributable to the appellant. But in fact, there was no formal extension of time from the end of the executive engineer.
But you carried on with the work.
I carried on work, but there was no formal extension communicating me that your time has been granted till this time, you have to complete the work by this time. That was never been communicated. Except in August 2021, when it was communicated to me that your time has been extended till 31st of December 2021. Now, thereafter, on 6th of July, the tender was, my contract was terminated. Now, lordship, I will show your lordship the relevant provision of the tender condition, which specify there are certain provision prior to termination of any contract. Now, without following those provision, the contract was terminated. My EMD was forfeited. Immediately filed a writ petition challenging the.
But how a writ petition is?
Lordship, I'll show to your lordship. There are dispute resolution clause is there, but the thing is, immediately after filing of the writ,
Page 105, clause 24.
yes, there is an alternative dispute resolution. Lordship, in fact, the Honorable Single Judge has granted me leave to approach the grievance redressal. But the thing is here, lordship, my allegation is against the executive engineer. That's why I have made him by name as a party respondent. There was certain demand of bribe that was not given, and as a result of which
You could have filed an FIR.
These are falling from the bench, my lord. In fact, my lord,
lordship, there are complaints.
NGOs to his benefit, my lord. My page 95, my lord, you'll find a third party interest was created.
Just kindly allow me to. I have stated that was the, I have never said because the third party was been subsequently given the tender. I have not made him party. So as on date, I cannot pray for set the clock black.
See,
only thing, lordship, kindly appreciate if your lordship kindly peruse the interim order. If your lordship kindly satisfy me that the termination was illegal. If your lordship
may be illegal.
If your lordship kindly as a direction to that effect, because without following the procedure, my tender has been, contract has been terminated.
You know, not only that, the Learned First Court, my lord, has directed a joint inspection.
I saw that.
Lordship has seen.
Lordship, I am aggrieved only to a portion. Lordship, kindly come to the impugn order. Impugn order is at page 92.
The relevant portion is at page 94. The termination clause which the Honorable Single Judge has recorded, Lordship, the third paragraph at page 94. Clause 52 of the tender term with regard to termination provides for a series of fundamental breaches which shall be a ground for the employer to terminate the contract. Now, Lordship, I'll take your Lordship to clause 52, which says that in case of fundamental breach, there must be a gap, 28 days complete stop work.
Therefore, there is a dispute redressal system on clause 24.
I know that.
And there is the arbitration clause in clause 25.
Yes.
And in fact, the learned judge would have been well justified in dismissing.
Yes, yes, I'm not agreed by
But
that
the learned
person.
judge has granted a direction to cause a joint inspection to be made on the work done by the
Yes,
petitioner
yes,
before the contract was terminated. To that extent, you have been saved.
Protected.
yes.
So
I'm not agreed
So
by that.
whatever work has been done, you are entitled for
But if
payment.
your Lordship is kindly with me that the termination was illegal, Lordship, the EMD and other deposit which they have forfeited
You
because of termination. Lordship,
you invoke
if the
you invoke clause 24. We'll fix a time limit within which they will adjudicate that matter.
yes, that is there in dispute resolution clause, that provision is there.
See, this is purely a commercial transaction. Assuming the other party was not the government, you could not have filed a writ petition. You would have filed a civil suit, either claiming compensation or specific performance. So merely because one of the contracting parties is the government, it's a pure private commercial transaction.
I'm not against the subsequent allocation of the work to third party. But the thing is, see, my contract has been
So that
illegally
is-
terminated and it will
So
appear from the face of the record.
that you can always agitate in terms of the general terms and conditions of contract, which clearly provides an elaborate procedure. You please invoke and this, please,
May I, for once, Lordship, may I take your Lordship to the relevant fundamental clause which has been referred as a ground for termination of my contract?
but then how are we to adjudicate that?
Lordship, kindly come to page 116 of the stay application.
Yes.
52.2 fundamental breaches. That was referred by the Honorable Single Judge. Fundamental breaches of the contract shall include, but shall not be limited to the following. 52.2.a, that has been referred by the Honorable Single Judge. The contractor stop work for 28 days when no stoppage of work is shown on the current program and the stoppage has not been authorized by the engineer. So, Lordship, there must be a 28 days stop work, complete stop work from the end of the contractor, without where the engineer has not approved such stoppage. Here, Lordship, kindly come to the stoppage notice and the termination notice. I will show only two documents. Lordship, kindly come to page 75. That is the suspension of work that was intimated to on 22nd of June. Lordship, kindly, it's page 75. Kindly peruse the date 22nd of June 2022. Suspension of work. So it is admitted that on and from 26th of June, the contractor issued suspension of work. And Lordship, kindly come to page the termination, page 77. On 6th of July, prior to expiry of 28 days, my tender was terminated.
21 days.
Contractor termination is आगे.
130.
And Lordship, prior to that, page 112, there is a provision in the tender document for liquidated damage. That was also not.
But what they say at page 77 is that the contractor did not respond to the letters issued for slow progress.
Page
meeting on
65, 66. Lordship,
notice memo.
these are page reply, these are not at all correct. I have shown various documents that I have prayed.
You please
These are the
invoke,
documents.
please come. This intra-court appeal by the writ petitioner is directed against the order dated 24/11/2022 in WPA 195/86 of 2022. The appellant had impugned the order passed by the respondent authorities terminating the contract awarded to the appellant by proceedings dated 6th July 2022. It appears that the appellant is not aggrieved by the award of the contract to
another contractor for completing the remaining work, but would challenge the correctness of the termination, stating that the suspension of work for construction of the road was directed to be ordered by proceedings of the executive engineer dated 22/6/2022, and within less than 28 days, the impugned termination was passed on 6/7/2022, which is in clear violation of clause 52.2 within bracket small a of the terms and conditions of tender. Apart from that, the various other grounds have also been raised, stating that factually there is no ground to terminate the contract. The learned single bench, after taking note of the relevant terms and conditions of contract, thought fit to direct a joint inspection to be conducted to assess the quantum of work done by the appellant before the contract was terminated. Contract was terminated on 6th July 2022, so that the compensation to be paid to the appellant can be worked out. That apart, the learned single bench has also noted that in clause 24 of the terms and conditions, there is a dispute redressal system, and liberty was granted to the appellant to work out his grievances in terms of the said clause. We also note that there is an we also note in clause 25, it has been stated that in view of the provisions of clause 24 on dispute redressal system, it is the condition of the contract, and there will be no arbitration for settlement of any dispute between the parties. We find that the dispute redressal system mentioned in clause 24 is an elaborate procedure where the aggrieved contractor will have due opportunity to put forth all his contentions. Therefore, we are of the view that the learned single bench was right in disposing of the writ petition by issuing the necessary directions for joint inspection to assess the quantum of work done by the appellant before the termination of the contract, and also simultaneously granting liberty to avail the dispute redressal system under clause 25 of the terms and conditions of contract. Thus, we find no grounds to interfere with the order passed by the learned single bench. In the event the appellant invokes clause 24 of the terms and conditions of contract by availing the dispute redressal system, the competent authority in terms of the said clause shall expeditiously consider the the prayer made by the appellant and conclude the proceedings as expeditiously as possible, preferably within a period of 3 months from the date on which such an application is filed in terms of clause 24 of the terms and conditions of contract. With the above observation, the appeal stands disposed of. Next.
Serial number 2. Two is identical matter. Lordship can pass similar order.
Same order.
May I file my affidavit of service?
Thank you.
Wait.
Next.
Serial number 3 and 4.
My lord, I am appealing for the appellate. My lord, 3 and 4, my lord, same order has been challenged by me and as well as by state.
And I prefer the state respondents, my lord. In the first appeal, I appear for the state, led by Mr. Hon'ble. And in the second appeal, it is serial number 4. This appeal has been preferred by the state itself against the same order.
My lord, here I am challenging the order page 59 of my special leave to appeal application. But we are the co-sharers and very much affected by these order, and the land in question involved in the writ petition is also, my lord, our land. We are the co-sharer. My lord, the page 59 is order starts page 59. Then your lordship kindly come page 60. Serial number 2. The state respondents are represented and contest the writ petition by placing a report of the officer in charge, Harwa Police Station, Bosirhat. The report states that there has been no instance of cutting of the embankments of Vidyadhari River from the Tanageria sluice gate to later sluice gate. The report also states that the local people did not support the case of the petitioner. The report ends with the statement that the police authorities are keeping vigil in the area to collect intelligence in the matter. And then, my lord, the objection taken on behalf of the state authorities appears to be contrary to the report of the learned counsel who was appointed advocate commissioner. And my lord, kindly come the report filed by the state authorities, page 58 of my application, which was filed before this learned single judge, filed by the subdivisional officer, which is specifically, my lord, stated the actual situation and, my lord, which reflects, my lord, our case in this appeal. My lord, serial number 3, page 58. As per petitioner's annexure shows the Mouja Atpukur in different plots number such and such, recorded Khutian number such and such in favor of Hemlata Ghosh. That is the petitioner in the writ petition. Far away from the river embankment of river Vidyadhari, approximate 1 kilometer to 2 kilometer. As per unit petitioner's record of right, enclosed annexure P1 shows that the character of land is Bilan. She is not the full share of plot number such and such. Malad, these plot, we are the co-sharers. In this plot, shows the petitioner in annexure P1, the record shows that 18 no shareholder in each plots, the recorded name in such and such, and it shows that property is joint owner recorded and Borgadar recorded, but those owners are not included in the party of the said writ petition. But SDO says that, and my lord, in that SDO's report, specifically, my lord, statement is there, serial number 6. Also, a point comes to our knowledge that Hemlata Ghosh, that is writ petitioner, came to an agreement through lease with some person. She has given her consent to allow the pisciculture in her recorded property for the year 2020, 2021, 2022, and lease value will be 8,000 per year per biga. Malad, these land used as, my lord, paddy cum fishery. 6 months that was used as, my lord, cultivation for almond rice, and, my lord, 6 months, my lord, in the rainy season that was used as a, my lord, fishery. And that agreement was made by the writ petitioner with the other person that this land will use as a paddy cum fishery. My lord, I annexed all the agreement that was executed by the petitioner.
No,
My lord, page 42.
What is the relief you sought for in the writ?
My lord, there was no at all, my lord.
Let us see the prayer in the writ petition.
Yes. Prayer in the writ petition is my step in my stay application.
Page number?
Page number. Page number 83 onwards. A writ in the nature of mandamus directing the respondent's authority to immediately make thorough and durable repair of the public embankment of river Vidyadhari in Mouja Atpukur and regular maintenance of the same on and after removing the wooden and concrete pond.
This prayer has been granted by the learned single bench.
Malad, only on the basis of report filed by the advocate commissioner. Malad, the SDO's report is different, and SDO's report supported our case. And this order has been passed only on the basis advocate commissioner appointed by the single judge, learned single judge. And my lord's SDO's report in favor of me. There was no, my lord, repairing required, and the already writ petitioner entered agreement with paddy cum fishery. If, my lord, fishery affected, then all the, my lord, farmers who were, my lord, enjoyed that fishery 8 bighas of land, that is very much affected. And
see, you please come to page 97.
97.
It is,
Yes.
Para 8.
8.
This is your writ petition 11025.
That is, my lord, their writ petition. My lord, I am not the.
So their writ petition means?
Means, my lord, writ petition is not implement us as a party. My lord, we are the affected person. After that, my lord, for that reason, we file, my lord, special leave to appeal along with stay application.
Now, who's for the writ petitioner?
Writ petitioner Hemlata Ghosh.
And who appears for them?
My lord, in earlier occasion, Learned friend appeared. He also
Mr. Shamul Bhattacharya is appearing for the writ petition.
he also filed opposition in this, my lord, in my
Where is
special.
he now?
Distinguished
Have
appeal.
you served?
Yes, my lord, ABD service is there, my lord. He also filed opposition in my special leave to appeal as well as stay application.
He is well aware of this matter, my lord.
He is not present here. He is not there today.
My lord, yesterday he is there, my lord.
Then Monday, we can have it on Monday.
Monday.
On what date it will come? Deepika? Next Wednesday.
Next week.
We have heard the learned counsels for the parties. However, one of the private respondents, that is the writ petitioner in WP, A 110205 of 2022 is not present today. Counsel for, not present. List on Wednesday in the same position.
My lord, in earlier occasion, my lord, interim protection has been made, my lord. No contempt proceedings, my lord.
On what date interim protection was granted?
My lord, that
Yes, that is not to initiate contempt proceedings.
my lord, in the meantime, they, my lord,
No, the interim order.
only up to Wednesday.
They have not yet.
No, up to
initiated
Wednesday.
any contempt
The
proceeding.
Adjourned date.
the interim
Till the adjourned.
protection granted by the order dated 9th February 2023 is extended till the next hearing date.
Grateful, my lord.
Serial number 5.
But I appear for the appellant.
Yes, sir.
My lord, I appear for the all private respondents.
The matter pertains to, my lord, public premises, which is governed by the Public Premises Eviction of Unauthorized Occupants Act. My lord, the appellant before my lord is the port authorities. Number the port authorities, my lord, have large tracts of land, my lord, which are unauthorizedly occupied by persons. Now, my lord, initially, my lord, we sought for help before the state government so that we can remove the encroachers. My lord, the state government did not give us any help. Therefore, my lord, we had come before the court initially by way of a writ petition. This is the second round of litigation. Now, in the first round of litigation, my lord, please have a look to my lord, first page 171. But in the previous round of litigation, my lord, first, at page 171, my lords will find, my lord, an order of a learned single judge dated 4th of May 2017.
Yes.
Directing the concerned authorities to file a report. Please take the next second paragraph. In view of the nature of the grievance expressed in the petition, I am of the opinion that a report be called from the DM over the aforesaid issue. Now, the report was with regard to the questions or the issues at page 172. A, whether any land belonging to the port authorities is unlawfully encroached by outsiders. If so, the number and the identities of the illegal encroachers and the area in their illegal occupation. C, steps taken or proposed to be taken by the respondent authorities, including the respondent number A, municipal authorities for removal. 172. For removal of the illegal encroachers, etc. Then where the report comes before the court at page 174.
Yes.
Apropos the above stated subject and reference, a field survey had been conducted by the concerned revenue inspector and office Amin. They have submitted a list of persons and the same is enclosed. Survey was conducted at various locations, etc. Now, please turn the page, Miller. Where this is a chart running into several pages, where Miller, the
Encroachers
name is in the second and the fourth column. Name and the nature of encroachment.
Yes.
But upon receipt of this report, Miller, the Honorable Single Judge felt that no, these people cannot be removed in this manner. Therefore, His Lordship was pleased to direct us to initiate appropriate proceedings for eviction, Miller, that your Lordship will find at page 239.
The writ petition was disposed.
Yes,
239.
yes.
Report filed on behalf of the state shows that there are certain unauthorized encroaches on the land of the petitioners. Report taken on record. Under such circumstances, it is open to the petitioners to initiate proceedings under the Port Trust. It should be public premises. Eviction of Unauthorized Occupant Act 1971 in accordance with law, if so advised.
Yes.
Needless to mention that the lawful orders passed by the appropriate authorities shall be implemented by the respondent police authorities in accordance with law. Then, Millard, we have started about 900 eviction proceedings. And Millard, which resulted in about 900 eviction orders. Number under the Public Premises Eviction of Unauthorized Occupants Act, Millard, we have certain procedure that has all been complied with. Now, when we go to serve the eviction orders, your lordship can imagine what happened. So Millard, we had to save our life and come back. Very well. Whatever it is, Millard, the eviction order, Millard, it was somehow being brought to their notice. I would not say that it was properly served, but it was somehow brought to their notice. Then, Millard, we had sought for police assistance from the appropriate authority, which obviously, Millard, went, Millard, unheeded too. Therefore, Millard, the second writ petition was filed before this honorable court, against which, Millard, we are before your lordship today. Now, kindly have a look to the orders.
Initially, there was a direction for page 423.
Yes.
And then page 425.
Right.
At 426 is the final order.
Right.
And what has happened to those eviction orders? Have they filed statutory appeal?
Yes. Millard, so far as the statutory appeal is concerned, Millard, here your lordship will find, Millard, the honorable single judge had passed directions that they should go and file statutory appeals. Now, please have a look to page 426. Upon hearing Mr. Banerjee, learned senior standing counsel, this court is of the view that the allegations of police inaction could not be substantiated. The police authorities had fixed dates for conducting of the eviction drive in execution of the order of the estate officer against the alleged encroachers, but the Port Trust could not finalize the issue. Now the learned advocate appears on behalf of the private respondent encroachers and claims that they are evictees. Their lands have been acquired by the Port Trust and they were supposed to be rehabilitated on the basis of a scheme. Unless they are rehabilitated, the ex parte order of the estate officer could not be executed with the help of police. The estate officer had initiated proceedings under the Act on the basis of liberty granted by this court. The documents in the writ petition reveal that notices were served on all the encroachers. But this is very important for me. However, it is specifically submitted on behalf of the private respondents that they were not aware of the proceeding. They were also unaware of the orders of eviction that were passed. Mr. Mukherjee, learned senior advocate for the petitioner, submits that all the encroachers were notified, notices were served personally and also by post, and 10 persons amongst all the encroachers appeared and contested the proceeding. The order of eviction of the unauthorized occupants were passed. No appeal has been preferred, and as such, the Port Trust now seeks to execute the order of the estate officer. In view of such disputed questions, this court directs that the Port Trust may approach the police authorities with further details, and in the meantime, this is what affects me. If the encroachers wish, they are at liberty to file their appeal in accordance with law. The appeal will be filed with the photocopy of the order of the estate officer, and the learned court will entertain the same upon an undertaking given by the petitioner that the appellant shall file a copy of the order upon receipt of the same from the estate officer. The issue of rehabilitation and merits of the order of eviction has not been gone into. If the port authorities approach the police authorities shall act in accordance with law. But my first respectful submission is on the point of grant of liberty to prefer an appeal. This, in my very respectful submission, is, I mean, the 226 court is not empowered to do so. Why? Because the statute provides 7 days, 12 days. 12 days to prefer an appeal.
But the learned judge has not given any positive direction.
Yes.
It goes without saying, assuming one of the encroacher files an appeal, it is barred by time. obviously the appellate court or appellate authority will not entertain the appeal.
Very well.
So therefore, you make an application to the police
Yes.
and let the police assess the situation. In the event they produce some stay order from the appellate court, then it is up to the police to consider that whether there is a stay order, etc. and take. Otherwise, they will offer you protection for eviction. That's all.
Well, my
The
problem.
judge has
Yes.
not said extended
Yes, yes, yes.
delimitation.
Well, I quite follow, my lord, what has fallen from the court. Now, my problem is, my basic problem is, my lord, whether an appeal is preferred or not, unless there is a stay, there is no impediment in executing the orders. Well, these are, my lord, understood. But the problem is, my lord, the state somehow, my lord, is inactive to provide me with this assistance. This is the only thing that I require.
That is obvious.
Yes.
Ask Chatterjee, he will tell you. And especially as on today, for the next 1 month, they will definitely. Such a big vote bank is there.
Well, what I respectfully submit, my lord.
It is all perennial problems.
Yes,
Perennial.
everywhere this is the problem.
And probably they are squatting for 20 years, 25 years.
My
Somebody-
lord, if I say so, but if my is a more than 50, 60 years, my instructions.
All right.
And they were, my lord, under to go, my lord, rehabilitation scheme that the state has entered upon. Some of them, my lord, are rehabilitated, some of them are left with. Subsequently, my lord, we came to know there has been some, my lord, hodgepodge between, my lord, the state and the Kotkala Port Trust.
Maybe,
And
whatever may be.
My lord,
You are
and also
not the
may I
owner of
say
the
this?
land. You are not the owner of the land.
Of
You are
course.
a ranked trespasser. A person who has not acted in equity cannot claim equity.
My lord, may I just say this, my lord, so
But
far as.
fortunately for you, the learned single bench in the earlier round said, please resort to the procedure by law. Otherwise, suppose they have bulldozed you.
Lordship. That I understand, my lord.
Either you advise your clients to file an appeal.
My lord, those are already filed, my lord. May I say this, my lord? Even, my lord, is the Act of 1971 as a my
No,
lord.
then
Senior friend,
when they take action for
it's already been filed, my lord. They were
executing
also
the order,
notified.
you produce proof to show, no, sir, this order has been stayed.
Yes.
I filed the appeal. Is there an automatic stay?
No. There has to be a
Yes, stay
application for stay.
In certain enactments, there is an automatic stay.
Right.
So you file a stay application.
Very well.
But until then, how can you resist saying that, no, the order,
No, my lord, we
order
say this, my lord, if your lordship, my lord, kindly please to appreciate, my lord. Even one of our point, my lord, that
if you
we were
want
not.
rehabilitation, please approach
No,
them.
my lord, may I say this? May I say this? I understand. But one of my, my lord, main contention in the appeal, as I have understood from the memo, that, my lord, we are not even given the notice of the proceeding.
That is a good
And, my
ground.
lord,
That's a good ground in your
yes,
statute.
of course, I understand.
So what
And, my lord,
we can
what they are
clarify-
trying to, my
No,
lord,
their apprehension is this observations at page 427
lordship.
tantamounts to a positive direction to file an appeal. We will clarify it is not so. It is up to the encroacher to file an appeal or not to file an
My
appeal.
lord, may I?
These are parallel lines. You file an appeal, take the matter to the
My
logical.
lord, it is already been filed. It has already been registered, my lord. May I also give the number in the other
So
application, my lord?
therefore, when the matter is being put to execution,
Yes.
you produce an order saying that, no, it can't be
My
executed.
lord, this is, my lord, may I hand over this lordship, may also take a note. This is the information sleeve, certified information sleeve given, my lord. This is a other copy of the, my lord, honorable second judge. Hey, take to them. This is the other copy for the honorable second judge. It's already there, is already filed. একটু দিন, কই কপিটাও দিন।
It is fine.
না, এটা দুটো কপি দিতে হয় না, আপনি please।
Information.
হুম।
It is filed in the court of
My
so Haldia.
Haldia.
So that court will grant stay, you move for stay.
And my lord,
In
so
the
far as.
meantime, we can't grant any protection to you. It's not your appeal. It's
Yes,
not
of
your
course. My lord,
petition.
what I say, if your lordship kindly, my lord, comes to this page 427, what my learned senior friend, my lord, was trying to, my lord, impress upon your lordship. The last but third paragraph, if may I read in my way, my lord, lordship may correct me if I'm wrong. In view of such disputed questions, this court directs that the port trust may approach the police authorities with further details. And in the meantime, if the encroachers wish, they are at liberty to file their appeal in accordance with law. So in effect, my lord, this is not such a, my lord, any blessings that we have received.
That is,
It
we'll
is
clarify
the
that.
learned single judge has
That is their
clarified.
apprehension.
Yes, no, learned single judge has clarified that in accordance with law, if we wish and if
They
we
want
advise.
it to be further clarified by a division bench. That's all.
My lord, I do not, I think, my lord, with the greatest of respect, my lord, this.
No, if you are genuinely interested, see certain any project of this nature, they will conceive the project like 30 years hence, 40 years hence, what will be my requirement?
Lordship.
Except for court complexes in the state, all other projects are conceived like that. In court complexes, they don't think about the number of lawyers will increase.
It is true indeed, but it is true.
They don't, when the land is offered for the judicial department, that forethought is, or that foresight is not there. 10 years down the line, what will be there? Now, why are we facing such a space crunch here? Because there is nowhere to develop, nowhere
Correct.
place. Car
Correct.
parking is an issue. Every day there's an issue. So therefore, these projects are conceived like that. So all the, public sector projects, 30 years, I may require more number of vessels will come in. I'll require container space. I'll require a yard, bigger yard, etc. So those lands will be lying fallow, vacant. So fortunately or unfortunately, all of you got inside.
No, it is not that it is, they are given, I tell you, Lordship, my instruction is they are running their livelihood and almost around 10,000 people are there.
Correct.
Around 10,000 people.
So this is,
and
I am
not
not
only
new
they are
to this.
residing, they are running livelihood, they are having their own business over
That is
there.
true, sir. I am not new to this type of litigation, but there the porters, Chennai porters were successful in evicting. They were successful in evicting. There were 40,000 people, but they were all rehabilitated. Nice apartments were given. Some of them were dock laborers.
And this is what Lordship has said, rehabilitate. This is what they also want, that since in all 50 years last
come, this intra-court appeal by the
and one technical issues, if may I raise this, one
you are not an appeal yet.
No, if I say this, my learned senior friend has accepted that there are multiple eviction orders. All cause of actions are separate. The revenues are concerned, it should be by all separate writ petition and all separate appeals. They have clubbed together. When the private litigants have come.
How many miscellaneous appeals you have preferred? How many miscellaneous appeals you have preferred?
So far as that
you have produced one slip.
We are being served together with one order.
Since you have preferred one miscellaneous appeal,
that is otherwise
this intra-court appeal by the portress is directed against order dated 22/8/2022 in WPA 166/26 of 2021. The writ petition was filed by the portress seeking for appropriate direction on the respondent police to enable them to execute the orders passed by the estate officer in proceedings initiated under sections 4 and 5 of the public premises within bracket acquisition of unauthorized occupants bracket close act 1971. Admittedly, the proceedings have ended in final orders, and according to the appellant portress, no appeals have been preferred against the orders of eviction. The encroachers, on the other hand, contended before the learned writ court that notices were not served on them and they were not aware of the eviction proceedings. This contention was denied by the appellant portress, stating that all the encroachers were notified, notices were served personally and also by post, and 10 persons among all the encroachers appeared and contested the proceedings. And thereafter, orders of eviction of unauthorized occupant was passed, and no appeal has been preferred, and the orders have attained to finality. Considering these facts, the learned writ court was of the opinion that the facts being in a dispute, disputed, the court directed the portress to approach the police authorities with further details. To this extent, the appellant portress does not appear to have any grievance. However, the further directions / observations made by the learned writ court is cause for concern, which has led to the filing of the present appeal. Mr. Dattu, learned senior advocate, appearing for the appellant portress, would submit that the learned writ court had no jurisdiction to permit the encroachers to file an appeal, and directions issued in this regard are clearly beyond the jurisdiction of a writ court. On perusal of page 2 of the order passed by the learned writ court, we find that there is no positive direction issued to the encroachers to file an appeal. Full stop. The learned writ court has not condoned the delay in filing the appeal, nor issued any positive directions in favor of the encroachers. All that has been said is, all that the learned writ court has done is to grant liberty to file their appeal, grant liberty to the encroachers to file the appeal in accordance with law. In our view, such a liberty is not required, since if the encroacher is aggrieved by an order of eviction, it is well open to the encroacher to approach the appellate authority in accordance with law. Therefore, the appellant portress need not have any apprehension that the observations made by the learned single bench are in the nature of a positive direction. Full stop. The Mr. So-and-so learned advocate appearing for the encroachers submitted a document stating that a document / information slip stating that miscellaneous appeal 13 of 2022 has been filed before the court of PST, before a court in Haldia.
Well, before the learned district judge?
Before the learned district judge, Haldia, which is stated to be the appellate court against an order of eviction. It is not clear as to whether all the encroachers have filed an appeal. In any event, if an appeal has been preferred in miscellaneous appeal number 13 of 2022, it is open to the said appellant to prosecute the appeal in the manner known to law. Therefore, we are of the view that the order passed by the learned single bench need not be misconstrued to be a positive direction in favor of the encroachers to file an appeal. And all that has been said is that the encroachers are at liberty to file an appeal, that too in accordance with law. Therefore, the appellate court should not construe the order and direction issued by the learned writ court as if to be a positive direction, enabling the appeal, enabling the encroachers to file an appeal, dehors the provisions of law. Full stop. We make it clear that it is well open to the portress authorities to approach the police authorities for necessary assistance for the purpose of execution of the orders of eviction if the orders have not been stayed. There is a complaint made by the portress stating that the state authorities are not cooperating with the portress authorities. The court fails to understand as to why the state is not extending assistance to the portress. And if that be true, is it a case where the state is supporting the encroachers, which if so, it is a very sorry state of affairs. The portress being a creature of statute and the land being allotted to the portress is in public interest. Therefore, the state should take proactive steps as and when the portress authorities approach the police authorities for necessary assistance for executing the orders of eviction passed under the said enactment. With the above observation,
But may I have two requests, Malad? But may I have request two things, that none of the observations made by
to raise all objections in the appeal stated to have been filed in appeal 13 of 2022, including the issue regarding the maintainability of the appeal.
May I make to this point that so far the observations made by my lords may not influence
obviously.
Kindly clarify in so far the merits. But the other point is other point.
Needless to state that since the learned writ court nor this court has gone into the merits of the matter, any observations made by this in this order will not in any manner affect the rights of both parties. Not gone into the merits of the order of eviction. Thank you.
And so far the other parties concerned is page 4 to 7. Because our stand is we were not even served with a copy of the eviction, and we have come to know from the writ petition. So we were allowed to permit the appeal with a photocopy of the order.
You do whatever you want.
But only one direction I require, my lord. We have approached the state a number of times, but please indicate that we'll definitely approach once again.
Let a copy of this order be marked to the Director General of Police, Kolkata.
West Bengal.
So that
West Bengal.
West Bengal, sorry, West Bengal. So that as and when the portress approach the concerned police authorities,
he is not a
the
party to
Director
the
General of Police shall issue necessary direction for affording necessary police assistance for
My lord, the
implementing the
Director
orders.
General, my lord, is not a party to the proceeding.
We'll say the registry is directed to forward a copy of this order to the Director General of Police, West Bengal. Next.
Serial number six.
I'm here.
My lord, may I take back that slip or lordship will
Yes.
keep it?
That is given already. Yes. Service complete? Oh, yes, this matter.
My lord,
Sir, what is this, sir? You see the photographs. He is not
Yes,
able
my
to get out of his house.
my lord, the thing is this, my lord, Lordship sees the
My lord, we'll
report of
kindly
the
look at the
police.
photographs.
Report of the police. Is a completely marketplace.
Maybe.
There are 6 markets are there. There are surrounding this premises, but there are 6 markets are there.
I will be referring to not yet open, my lord. I will be referring to section 300. My lord, will
There may be
kindly, my lord, will look at-
700 markets also.
Yes.
But if the man is not able to come out of this house and the municipality is not, the corporation is not able to regulate the hawkers, it is absolute failure on your part. Absolute failure.
But
Sir, if the
Well, we
shops are
kindly
there,
look
wait, sir. Sir, please wait. If shops are there, you can understand the shopkeeper may have a two-wheeler. He may park it, open a shop and do the business. Some customers will come in bicycles, two-wheelers, park it for 5 minutes, 10 minutes. Photographs show on the pavement, on the road margin, encroaching the road, hawkers have put up permanent stalls. That needs to be regulated.
that may be, of course, my lord, that may be looked into jointly with the police authorities, because so far as the parking is.
But the police says, now the learned grid code says, nothing can be done. How is it so?
No,
Police
no,
report
that
says.
that is not, my lord. May I tell Lordship, my lord,
Well,
the
may I
press,
only-
no, crux of the matter, I think, my lord, has been, my lord,
No,
pleased
first,
to
first
understand.
you do one thing,
My-
conduct an eviction drive, all these hawkers who are sitting in the road margin. Rehabilitate them in terms of the hawking committee rules or whatever it is, allot an area, 5 by 5.
In
Make
fact, my lord, drive is conducted time and again. Then, my lord, again, my lord, the hawkers will come up. That
Therefore, it's
typically will
absolute-
come up. The police, my lord, police and the authorities of the Kolkata Municipal Corporation, unauthorized hawkers, of course, my lord, the drive is taken place in some occasions. The police has also, my lord, reported accordingly, my lord, that you see, my lord, the report. So far as that period is concerned, at page, my lord,
You
This is
see
the,
this
my lord,
photograph?
elate- my lord, no, my lord,
My
I
lord,
have
this is
not
my
yet.
photographs, my lord.
I have not yet.
Give
I
this
have
one.
not yet.
the photograph.
My lord, that, my lord,
Yesterday it has-
photographs
it was
are
taken
there.
as-
My lord, we cannot deny this, but at the same time, Lordship, kindly have a look at this report, my lord. It is the, my lord, the latest report, my lord, to be placed
I have
before
not
your lordship.
supplied-
না না দেবো, নিশ্চয়ই দেবো, নিশ্চয়ই। আমি এক্ষুনি দেখলাম, just now হাতে এলো, নিশ্চয়ই দেবো।
Lord,
Now, my lord, the difficulty is this, if your lordship kindly have a look, my lord, what my learned friend said on behalf of the municipality also, the marketplace area and how many markets and the people are, my lord, regularly, my lord, going and coming there. All are, my lord, wholesale markets.
But you see page 10, para 10. How can the police take such a stand? Full of hawkers frequently, the problem likely to be faced by him cannot be addressed either by KMC or the police. How we are not able to understand?
My lord, last line, my lord, duty traffic auditors, or duty traffic orders consistently endeavor to provide relief to the
No, no.
petitioner regularly, my lord, regularly. It is the,
Please come.
My lord,
We have heard the learned advocates for the parties. The writ petition projects a very sorry state of affairs where neither the officials of the Kolkata Municipal Corporation or the concerned police authorities are helpless and are turning a blind eye to the encroachments and trespasses on a public road on the pavement, blocking the
his allegation unauthorized parking in front of his chamber, my lord.
No, my
blocking
house,
the
my lord.
ingress and egress of the petitioner to his property. That apart, there is an unauthorized parking in the area for continuously, and as per the police report filed before the learned writ court, the police authorities have virtually stated that they cannot do anything in the matter. Today, the learned counsel appearing for the state has produced a written instruction given by the Deputy Commissioner of Police, Traffic Department, Kolkata, dated 10th April 2023, And from paragraph 10 therein, we find that the authorities have stated that the problem faced by the writ petitioner cannot be addressed either by the Kolkata Municipal Corporation or the police. We fail to understand as to or the police, and this is quoted from the order passed in the writ petition. We fail to understand as to how such a stand could have been taken by the police authorities. The photographs which have been produced before us show that not only there is unauthorized parking, there are street vendors who have virtually put up permanent stalls on the road margin, blocking the road, and as a result of which there is congestion. We fail to understand as to why the authorities are unable to enforce law and order in the situation in the area in question. Therefore, we direct the concerned police authorities to conduct a large-scale eviction drive and ensure that all the hawkers are removed and rehabilitated in terms of the scheme formulated by the state government in an unobjectionable pace, and ensure that there is no unauthorized parking. This exercise shall commence from Monday, before which public notice may be given. Notice may be given to the general public of the area, and stating that if they continue to do, they will be forcefully evicted from Monday onwards, within bracket date. List the matter on so and so date. Action taken report be filed by the police authorities as well as the authorities of the Kolkata Municipal Corporation. Next.
Well, extremely grateful, my lord.
Serial number 7.
The only thing, my lord, instead
us
of
see,
Monday,
sir.
no, only thing.
If
but
there is a will, definitely it can be done.
That's true. That's true. But
You
only-
rehabilitate them, do whatever it is.
Extremely grateful.
Yes, sir. Next.
Serial number 7.
No time today, Mr. Shah. Rahul, yesterday we have day before yesterday, where Mr. Senior Counsel, Mr. Mitra was appearing in that cross-examination
Yes,
matter.
my lord.
You are not there in that matter.
Lord,
Which
I
matter
was-
you not see?
Who was there for the,
No,
who was instructing Mr. Mitra? I think Ketan, all. We have disposed of. They agreed not to rely upon those statements. I thought you are appearing. When we'll have it?
Kindly keep it next Friday, your lordship.
All right, next Friday.
Serial number 8.
Contempt petition.
Yes, but
Yes. Who is the contemnor?
My lord, I appear on behalf of the alleged contemner, your lordship. My lord, as indicated, my lord.
You have paid the.
Yes, my lord. Yes, my lord. I have paid.
No.
Yes, paid,
Hmm.
but not this section 17B payment has not been paid. Lord, on the basis of the award, I have filed an application under section
That is
33C.
C2.
The labor code determined the amount that they did not pay. I have gone for execution. Or during the pendency of execution, they have preferred an appeal. Appeal is pending. Section 17B has been allowed. That execute the determination or under section 33C2 has been paid to me, not this amount. Up post period of the award not been paid.
This 7,97,000 and odd.
Yeah.
References which amount? 33C2 order.
Lord,
No, they have produced it.
33C2 amount has been paid since 2011 to 2019. That amount has been paid.
Very good.
But they have preferred an appeal during the pendency of the appeal. I am entitled to section 17B.
Yes.
That has not been paid.
How much is the amount?
My lord,
But
2 lakh 30,000.
Then you pay that, we'll adjourn the contempt petition. Easy. Till the appeal was disposed of, he is entitled for 17B.
Yes, my lord.
The amount we have heard so and so. The amount which was computed by the Labour Code in an application filed under section 33C2 of the ID Act has been settled, and a banker's check for a sum of rupees 7,97,838.56 paise has been dated 5th June 2023 has been handed over, drawn in the name of the applicant Tanmoy Mitro, has been handed over to Mr. Rakshit, learned advocate appearing for the applicant. It is submitted by the learned advocate for the applicant that till the appeal was disposed of, the applicant is entitled for wages under section 17 capital B of the ID Act. This has been calculated to a sum of about rupees 2,50,000.
My lord, appeal is pending. My lord, last drawn salary is your lordship will find from the application itself.
No, about 2 lakh appeal is pending. Appeal is pending. It's not.
7,000 to 60.
There will be a direction to the respondents to settle the wages payable under section 17 capital B of the Act during the pendency of the appeal and continue to pay the same till the appeal is disposed of. This direction be complied with within a period of 4 weeks from the date of receipt of the server copy of this order. With the above observation, contempt application disposed.
Grateful, my lord.
Next.
Serial number 9.
Application for contempt, my lord.
Who is the contemptor?
That I have not served because it is yet to be admitted of the order, my lord, passed by the court below 13th additional district judge, my lord, Alipur. The orders, my lord, have been violated. My wife, my lord, has also filed a criminal case against me subsequent to the filing of the revisional application that I have abused.
But why can't you move the concern?
That this application is maintainable, your lord.
We are aware of that, sir. We are aware of that. I am personally aware of that.
I do not have that audacity to say, my lord, your lordships are not aware.
No.
I am saying, my lord, that your lordships knows that the lower court, now the problem is, since the revisional applications are pending, the court does not want to touch the matter, my lord, even though there is no stay.
In the revisional application, if there is no stay, nothing prevents the court from.
Then, my lord, kindly pass this order, my lord. That
No,
the
what
lower
we will
court-
do is, we will say that there is a willful disobedience of the direction issued by the court. And though revision application has been filed, no
No,
stay.
revisional applications, they have filed challenging the order.
But there is no stay.
No stay, but the
So
lower court
therefore,
says.
we will give you liberty to approach the concerned court by way of an application for contempt, and the court will take it up. As long as there is no stay, there is no bar for the court to take it up. That will be a better remedy because he can be summoned and the court can strike out his defense also.
At least, my lord, 4 dates have passed. The court says High Court is taking up the matter.
No, we will clarify.
And is it possible, my lord, subject to correction, to direct the court, my lord, to take up my application?
Yes, why not?
And to
As long
decide
as
the
there
issue.
is no stay, no court is prevented from proceeding in the matter. Mere pendency will not amount to stay.
Apparatus stay.
It has been clarified. In fact, Supreme Court has clarified, saying that High Court should issue a circular to all the district courts, all the courts in the districts, saying that pendency of an appeal should not be construed as stay. Secondly, merely because notice is ordered, let us assume in a 482 petition against a rejection of, or a criminal revision petition against a rejection of a discharge application. Moment notice is ordered, they pack up the entire records and send it to the High Court. The courts have said no, that should not be unless the records are summoned. The court should be continuing to give dates and hear the matter. This contempt application has been filed alleging willful disobedience of the order and direction dated.
My lord, there are 4 orders: 21st September 2022, 28 October 2022, 12th December 2022, and 21st December 2022.
Yes, Mr. Bose, a mediator has been appointed.
Mediation failed.
Failed also.
You can bring this fact to the notice of the learned court below.
My lord, there is none to hear, my lord. The court says only court is frightened in a way that the High Court is taking up the matter. That is the reality, my lord. Only a foolish optimist can deny the reality of
Willful
events.
disobedience of the orders dated 21/9/2022, 28/10/2022, 12/12/2022, and 21/12/2022. Passed by the learned additional district judge, 13th court at Alipur. It is not in dispute that the orders passed by the learned trial court are subject matter of challenge before this court in a revision application. Further, it is
2 revisional applications.
It is stated that
There are two revisional applications.
revision applications, and it stated that there is no order of stay granted in the revision application, though there was a direction by in the said revision applications to appoint a mediator to examine as to whether a settlement can be arrived at.
No,
The learned
mediator was
advocate for the
appointed, failed.
applicant submits that mediation has failed. Since it is submitted that there is no stay of the proceedings before the learned trial court, nothing prevents the learned trial court from taking up any of the applications which may be presented by the applicant before the court. Therefore, we dispose of this contempt application by granting liberty to the applicant to file appropriate application before the learned trial court. And in the event there is no stay granted by the revisional court at the instance of the respondent, then it is well open to the learned trial court to take up the application for consideration and proceed in accordance with law.
I'm extremely grateful.
You are involving the police authority, Mr. Bose, to take your child.
Yes, otherwise, my lord, my wife has taken,
An unfortunate.
my wife has filed her case, my lord, against me, sexual abuse of the child.
Next,
After 5 months.
unworkable order. It has come, no? No, you call
It will
one.
be very difficult to enforce.
Call 10. You call 10. All right, let the second file.
Serial number 10. Well, this is my appeal.
May I get a copy from my learned friend?
Copy has been served.
Millard,
Hard copy served. By hand delivery.
A soft copy. Millard, fact, Millard, that petition is not opening in my soft copy. Takes it up on Monday, Millard, no difficulty. Or he gives me a hard copy. If he favors me, Millard, I can assist your lordship.
Well, it has been served, Millard, by hand, Millard.
To
I
the
can give him
ECL.
a copy. Where is that?
ECL, Millard. No, Millard,
This is
this,
a-
Millard, they send me by a soft copy. This soft copy
This is a tender matter.
But this is a tender matter, Millard. My case is, Millard, that work order was given to me. The work was to be completed within 6 years. Now, when the tender was issued, Millard, the tender was issued, as your lordship knows, Millard, there are two types of mining. One is open cast mining, the other is underground mining. The tender was issued for open cast mining. Now, Millard, thereafter, Millard, series of correspondence, Millard, they could not give me the land. Subsequently, I come to learn, number one, the ECL authorities did not have the environment clearance. Number two, they did not have the permission of the competent authority even to undertake open cast mining, whereas my agreement has been executed with me. Number three is when they get the ultimate environment clearance, certain conditions were imposed, like the period of the work was reduced from 6 years to 5 years by the appropriate authority, not ECL. Number two, they say that we cannot utilize the village roads for transport of the coal that has to be
According to you, it is impossible of performance.
Yes.
So it is a frustration.
Yes.
Then you invoke the consent clause.
Well, I have already invoked at least 5 letters are there. They are not adhering to that. On the other hand, they are terminating.
You initiate arbitration.
Yes, arbitration is there.
You
Designated
because
forum
once
is the
it is
commercial code.
contract
My learned
gets-
friend wants a writ could.
See, he may say, I am a, government of India enterprise.
Yes.
I'm a public sector. You are a public
Yes, yes.
sector.
Yes,
You are a
I'm
public
ECL.
sector. I have got this clearance, etc. There are two ways of, if there is a dispute redressal mechanism under the contract, that is discussion, mediation before resorting to arbitration.
Three tier.
Three-tier.
Three-tier.
If it's a three-tier, you do that, then they'll have to facilitate giving you access to the open cast mine, transporting material, railway track, etc. If nothing is possible from your side, then the contract gets frustrated.
This is
You
exactly
sue for
Millard, the
damages.
learned
Millard,
judge,
I have
I
got
put
two-
Millard held.
I've got two problems. The first is, Millard, they are intending to terminate my contract. Number two is, Millard, they are invoking my entire
Unconditional bank guarantee.
bank
How can
guarantee.
it stay? This court
Therefore,
has turned into a
yes.
mad mouse on an unconditional bank guarantee.
You file an application for arbitration, then move section 9. That will be the.
Millard, may I say this, Millard? Kindly permit me to say this, Millard. Your lordships have held, Millard, arbitration is not an absolute power.
but not in these sort of.
Yes, now in this case, my lord,
But
He wants foreclosure of a contract.
wait, sir.
I'm sorry. I'm
All
sorry. I'm
four
very-
of us are talking means what?
I'm very sorry. I apologize.
Sir, you imagine this Eastern Coalfields is not a government of India enterprise or not a public sector. It was not maintainable. So this is purely a commercial transaction between the petitioner who had his wife. See, these are all due diligence. You could, before entering to the term contract or before bidding for the contract, all the necessary clearances should have been uploaded. You could have asked for queries. So the due diligence needs to be done by the intending bidder. So at that post agreement stage, if suppose something crops up, let us assume there is a public agitation. Obviously, you can't be held responsible.
Right.
It is for them to provide necessary assistance. So here you say that it is impossible for X, Y, Z reasons. Let the arbitrator decide whether you are justified. In the meantime, seek for appropriate interim protection under 9.
well, please consider, my lord, the facts of this case. Kindly consider the facts of this.
Yes.
My lord, for your lordship's assistance, my lord, we have prepared a short list of dates because there are a lot of documents, my lord. Yeah.
I'll request your lordship to take it up on Monday. I don't have any papers, my lord, with me.
But in that case, kindly take it up on Wednesday.
Wednesday.
Well, let it be understood, my lord, in the meantime, my lord, they
There
issued
was no
termination
order,
notice.
my lord. There was no
Well,
interim.
then
order.
kindly take it up today. My learned friend, my lord, cannot have both.
I don't have a scrap of paper.
No, we have served it. Your lordship have seen it. I'm not supposed to serve the learned council.
Monday.
Monday. Takes
Well,
it up on Monday.
Well, Monday I'm not here, my lord. In that
I have
case,
no difficulty,
Tuesday.
takes it up on-
Tuesday.
Tuesday takes it up.
My lord, let them not invoke the bank guarantee in the
How can
meantime.
that be done? My lord? Unconditional bank guarantee, he wants us.
But then at once they say
Monday takes it up.
papers have been served.
Kindly takes it up on Monday, my lord. My lord,
On
takes it up.
Monday, senior counsel is
Takes
not.
it up on Tuesday, my lord.
But in the meantime, if you frustrate the entire.
I have not issued an invocation letter also.
My lord, it is there, my lord. We have prepared a supplementary affidavit. Kindly have a look through this.
You take instruction.
I'll take instruction. My lord, the learned court, my lord, said, my lord, you work. Otherwise, you give him a notice. 15 days time was given. Please work. Because all the
Then
requisite.
we can't, we won't be passing an order because unless we hear.
My
them.
lordship has said, my lord, I'll, my lord, abide by it, my lord. Till Tuesday, my lord, keeps the matter and lordship hears me.
Wednesday.
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 My lord, only thing, my lord,
That
it is
I said, my lord, to the
No,
court also.
You instruct your client.
Yes, that is said, my lord. Since lordship is hearing the matter, lordship said, you please don't do. Ultimately, the read got this.
Request of the learned advocate for the respondent. List on Wednesday and in the same caption. Next.
my lord, the supplementary affidavit will be
Yes,
kept on
right.
record. I'll serve a copy.
Supplementary.
That I said to the trial court also, my lord. And she was very happy, my lord, I did not take any steps.
Item 11.
Serial number 11. 5 months I have not taken any steps.
I'm grateful, my lord.
Let we have appearing for the response. Brief tabak or.
Lord, I'm for the petitioner in item number 11. This is a matter of service tax where section 73 was invoked and an order was passed. During the entire proceedings, we had submitted a multiple number of documents regarding actually the fact of the case is like the SSC provides service which is exempted from service tax as per notification number 25/2012. During the entire proceedings, we had submitted multiple number of documents establishing the facts and assessing the fact that we are exempted from tax and we had paid the tax which were practically liable. At the time of passing the order, the assessing officer or the concerned officer did not consider the submissions, and in fact, they said that we had not submitted a lot of documents which have already submitted.
But why have you not filed an appeal before the commissioner?
My lord,
You could have filed.
Well, a
See,
similar
don't
issue, your
bypass this
lordship has
remedy.
already decided.
Pardon?
Similar issue, your lordship has already directed that they should approach the statutory alternative forum. Well, these are the.
And what was the limitation? 60 days.
Yes, my lord.
And when did you file the writ petition in February 2023? The order was passed on 27/12. It was well within 60 days.
Yes, my lord, we are.
We will extend the limitation. Within 10 days, you file an appeal.
My lord, here I want to mention something. The department has already gone for an appeal for wrong calculation of service tax during the pendency in
My
front
lord,
of the
that
single.
liberty has been given by the Hon'ble Single Judge. That is at page 80 of your lordship's.
No, this is an appealable order. Don't bypass the appeal remedy.
My-
The commissioner can look into all your grievances. If he wants, he can remand the matter, or if he wants, he can call for a remand report. He'll reappreciate the entire thing and he will hear you in person and then this.
My lord, I just want to mention something. The department has already filed an appeal.
So yours will be a cross appeal.
My lord, leave may be granted to participate in an appeal instead of
Yes.
filing
This
separate appeal.
intra-court appeal by the writ petitioners are directed against the order. 24th March 2023 in WPA 4969 of 2023. The writ petition was filed challenging an order of adjudication dated 27/12/2022 passed by the Additional Commissioner, Central Tax, CGST and CEX Commissionerate, Aura. Admittedly, the order impugned in the writ petition is an appellate order, appealable order, as appeal lies to the Commissioner of Central Tax, within bracket, appeal Roman 2, Kolkata. The learned single bench was right in refusing to entertain the writ petition on the ground of availability of an efficacious alternate remedy. That apart, we are informed that the revenue has also preferred an appeal with regard to certain miscalculation of the amount of service tax payable by the appellant. The learned advocate for the appellant would strenuously contend that the order passed by the adjudicating authority dated 27th December 2022 is in violation of principles of natural justice in as much as the documents which are placed for consideration were not taken into consideration by the adjudicating authority. If that be so, it will be well open to the appellant to agitate all the points before the appellate authority, and the appellate authority will be able to appreciate and reappreciate the documents which are brought on record and take a final decision in the matter in the light of the office. Taking note of the fact that the writ petition was filed well within the period of 60 days from the date of receipt of the order of adjudication, we are inclined to grant liberty to the appellant to file a statutory appeal. In the result, while refusing to interfere with the order and direction issued by the learned writ court, we direct the appellant to file an appeal as against the order of adjudication dated 27/12/2022.
My lord, I just want to mention the department has already filed an.
No.
You have
to file a
challenge their appeal.
Before the concerned appellate authority, and if such appeal is filed within a period of 15 days from the date of receipt of the server copy of this order, the appellate authority shall not reject the appeal on the ground of limitation, but consider the appeal on in accordance with the relevant statute. Next.
Serial number 12.
My lord, I had filed this appeal, my lord.
What is this?
Yes, my lord,
Cancellation.
today I am only praying, my lord, after filing this appeal. My lord, I had challenged the search and seizure, particularly on the ground that they had no authority. And the respondents were not providing me the authority at all to show that they had the documents. Now, my lord, after filing of this application, they have filed their affidavit in opposition, from which I find that they had no authority. And I am praying today to leave to file a supplementary affidavit to bring on record, my lord. So,
I do not
What
understand.
was the writ petition for?
my lord.
With challenge upon the search and seizure, my lord, and seizure of cash also.
Yes.
So we have the authority under the GST Act. If your lordship kindly sees the impugn order,
I'm not today on that.
Madam wants to file some supplementary
A supplementary affidavit which will show, my lord, is palpably illegal.
Of the learned advocate for the appellant, matter stands adjourned by 2 weeks with leave to file supplementary affidavit, copy of which should be served in advance to the learned advocate for the respondent state. List the matter under the same caption after 2 weeks. Give a date. Next.
I'm grateful. My lord, my affidavit on service may be kept on record.
What is it? Affidavit?
Affidavit of service may be kept.
Affidavit of service.
I'm
taken on
grateful.
record.
Serial number 30.
I am for the respondent.
I'm grateful, my lord.
What is it? 148 AD.
Action against 132. And 132, my lord, very limited issue is there. 132 provides that the stock in trade shall not be seized except making a inventory. My lord, what have the SSC is a manufacturer and dealer of jewelry.
No, the impugned order has only adjourned the matter.
The impugned order did not deal with it. The impugned
No,
order,
sir.
my lord,
Let this matter appear in the list on 8th May before the regular
He
bench.
asked for time to file a supplementary,
Yes.
which he did later on.
we prayed two things before the learned trial judge, Justice Bharadwaj. Lord, one, release of my goods. Second, that my case.
The regular court will consider.
My lord, the thing, the situation is my business has been stopped.
You
because the
mentioned
entire-
before, Mr. Muraka, please mention before the regular court and Mr. Vivek will
Your
mention.
lordship, kindly, it's a very simple, straight away the section says. The section says,
This
my lord,
intra-court appeal is directed against the order dated 25/4/2020
may your lordship may indicate that the court may take it up
in
early.
WPA number 7637 of 2023. On reading of the impugned order, we find that the court has adjourned the matter and court has directed the matter to be listed before the regular bench. The court has also noted the submission of the learned senior counsel for the appellant, who prayed for leave to file a supplementary affidavit within a week. Therefore, we find that this order impugned is not a final order and an appeal against the order is not maintainable. Hence, the appeal is dismissed. We give liberty to the petitioner to mention before the concerned court for early listing of the writ petition. Next.
Applied.
Serial number
You may not,
14.
my lord, may not dismiss, otherwise it was the merits it may be taken
We
as.
make it clear that the merits of the matter have not been gone into. Full stop. Next.
Serial number 14.
14.
I beg to appear for that.
I am for the respondent.
What is this?
My lord, 148 AD order, my lord, has been there 1819, my lord. So, my lord, and then similar circumstances, many order, my lord, restored your lordship in the 148.
So, my lord, with regard to my lord, the reply which my learned friend has taken out with regard to my lord, the notices under 148 AB, that has been my lord dealt with by the assessing officer while passing 148 AD, and my lord, the learned court below my lord have gone into that matter, did not find anything on merit to my lord entertain. This to entertaining is with regard to the
He went before the court alleging, stating that there is violation of principles of law.
Possibly not, my lord. If I could, my lord, indicate, let my learned friend, my lord, indicate that, my lord, that will be tantamount.
What is the violation?
My lord, violation of principle of natural justice, because my lord, show cause notice issued, my lord, saying that information received from inside portal, but law says that AO shall make the inquiry, number one. Number two, my lord, alleged materials and relied upon documents not supplied. And my lord, two names.
Did you seek for those documents?
No, my lord, not seek, my lord.
Then you see your written submissions, page 57, you have not sought for anything. Unless you seek for documents, then obviously you at page 158, he says, drop the ongoing proceedings. That's all.
My lord, another thing, my lord, two names brought in the order, which was not there in the show cause notice, my lord.
No, if you had sought for earlier cases, were saying that, sir, I don't have any documents, please supply these documents. That might have been your request.
Yes, my lord.
If that was not considered, we have interfered. And while passing a AD order, some other material which is never put to the SSC would have relied upon. We have quashed the proceedings. But here he has participated. You
My
see,
lord, another
57.
Yes, my lord. Another thing, my lord. I will show your lordship, my lord. My lord, first kindly see, my lord.
So after this, he will issue you 3 notices. In that you participate.
Yes.
We'll grant you liberty.
No, after 148 AD order, my lord. After 1 year, they issued 143 2 notice. My lord. That is different, my lord. But problem is, my lord, in the.
Yes, I'll return to that.
Having not raised what to do.
Kindly see, my lord. Once.
See, otherwise, we have never hesitated to quash the proceedings.
My lord, similar
Because
circumstances.
reopening is a very, very powerful.
Similar circumstances in the case of Kunal Daga, my lord. Similar fact.
Kunal Daga, different. Facts were different.
No,
that is why you come to page 57. What has he said? I deny and dispute the allegations that during the relevant financial year, I provided accommodation entry bogus bill. Then he has said that all purchases are genuine. So this was considered. You could have filed documents. You have already filed documents. He has
Yes.
considered that.
My
and
lord.
Passed an AD order.
Yes, my lord. Kindly see, my lord, AD order. My lord, second para, my lord. Page 60, my lord, page 70. Kindly see, my lord. First para, page 70. It has been established that Messrs. Dibbang Delcom and in the second para, my lord, in Eastern Cells, that both names, my lord, and alleged material not there in the show cause notice, my lord. This is my first allegation, my lord. And secondly, my lord, kindly see, my lord, at that page, sixth para. Sixth para, my lord, they have written that notice was issued and fixed for hearing on 29th March. But, my lord, not for hearing, my lord, only for submission of reply.
Where are you reading?
First, my lord, I am reading page 70, para 1.
Yes.
It has been established that Messrs. Dibbang Delcom Limited was indulged in such fake purchase bills number of entities. This Dibbang Delcom allegation, my lord, was not there in the show cause notice.
Let us see the show cause.
Yes, my lord. At page 54, my lord. Kindly see, my lord. Page 55, operative part. May I read, my lord? Credible information has been received from through inside portal. Yeah. And, my lord, thereafter, my lord, the second para, the SSC is stated to have allegedly purchased such and such amount from Boliram Sharma and DS Bituminous. Whereas here the names of Dibbang Delcom and Eastern Sales, which was in the order, that was not there, nor, my lord, alleged material supplied. Secondly, my lord, in inside portal, the law says, section says that AO shall make the inquiry, but here AO did not make the inquiry, my lord. This is the my second point. My lord, my third point is that, my lord, in the kindly see, my lord, kindly have a look at page 70, para 6, my lord, order. Here.
So 29th of March was the date fixed for filing your response.
Response are here written hearing, not, my lord. No hearing was given, my lord.
And page 71, he says assessee did not submit any other documents such as bank statement.
Yes, my lord. Yes, yes. Yes, my lord.
You have submitted.
Yes, my lord. Page, bank statement at page, my lord.
What do you say, Mr. Mitro?
With regard to
67, my lord.
Factual aspect.
No, you have to give some training to these fellows. Was it time bar, getting time bar?
No, my lord.
He has already filed the assessment, my lord. This, the
No.
return.
No, that is different.
Yes, produce the statement of accounts.
Statement, not
the
concept.
income tax returns, and this Eastern Sales and this Dealcom Private Limited.
Dibbang's Dealcom was not there in the show.
This intra-court appeal by the writ petitioner is directed against the order dated so and so, dismissing the writ petition filed challenging the order passed by the respondent under section 148 capital A within bracket small d of the Income Tax Act 1961, year and after, referred to as the Act for brevity. The order was challenged on the ground of violation of principles of natural justice. The learned writ court declined to interfere with the said order on the ground that the appellant can raise all issues in the reassessment proceedings. Agreed by such order, the appellant has preferred the present appeal. We have perused the show cause notice issued by the assessing officer under section 148 capital A within bracket small b dated 22/3/2022, and we find that the allegation made against the appellant assessee is to the following effect. Sir, please, page 55, sir, I'll mark it in pencil. The appellant had submitted his response within the date fixed, namely 29th March 2022, and has also enclosed income tax returns and other documents. Admittedly, no opportunity of personal hearing was granted to the assessee. In the order dated 6th April 2022, passed under section 148 capital A within bracket small d, there is a reference to certain transactions done by two companies, done with two companies. Sorry, sir, done by, namely Messrs. Devanshu, DVYANSHU, Dealcom, DEALCOM Private Limited, page 70 it is there, and Messrs. Eastern Sales India. Admittedly, in the show cause notice, there was no such allegation concerning these two companies, the appellant assessee. Furthermore, we find that the hearing was not fixed by the assessing officer on 29/3/2022. But the show cause notice states that the E-response should be filed by the assessee not later than 29/3/2022. Therefore, this is also an error committed by the assessing officer. The assessing officer states that the assessee did not submit documents in support of their claim. This finding also appears to be incorrect, since there are enclosures along with the response submitted by the assessee dated 29th March 2022. Thus, we are of the view that there has been violation of principles of natural justice, and the matter has to be remanded back to the assessing officer for a fresh decision. Accordingly, the appeal is allowed. The order passed and the writ petition is set aside. The writ petition is allowed. The order passed under section 148 capital A within bracket small d of the act dated 16/4/2022 is set aside, and the matter is remanded to the assessing officer for fresh consideration. The assessing officer is directed to furnish all relevant information concerning those two companies and other information wherein the assessee has been roped in, and 15 days time should be granted to the assessee to submit their additional response. Thereafter, an opportunity of personal hearing be granted, and fresh orders be passed on merits and in accordance with law.
I'm grateful.
Next.
Appearance slip.
Can we take it up after 19?
Serial number 15.
Yes.
My lord, I am appearing for the respondent.
The extended period of limitation.
Yes.
What happened to your writ?
My lord, my lord, there are two periods of limitation prescribed under the service tax law section 73. One is the normal period of limitation, your lordship, which is 30 months from the due date of filing of my return. Second is 5 years from the due date of the filing of the return. In my case, your lordship, both the limitation periods, your lordship, are, but the so-called notice has been issued beyond even 5 years, your lordship. The notice has been received by me even beyond the 5 years. So, my lord, the so-called notice is without jurisdiction.
Now, why your writ petition was dismissed?
My lord, it was dismissed because, my lord, I received the so-called notice on 27/4/2021. But thereafter, I immediately filed a reply on 25/5/2021. So
immediately you filed.
Yes, we filed, but they did not do anything about it. Then in the month of February 2023, further they sought to fix a date of hearing. Then we again looked at the matter and reviewed it, and it was felt fit that since the date of limitation, since the so-called notice has been issued even beyond the extended period of limitation, and the issue of jurisdiction goes to the root of the matter. It can be raised at any stage.
Now, final order has been passed, adjudication.
No, nothing has been done. Final order has not been passed.
Your writ petition was dismissed on the ground, you came late.
Late, yes, my lord.
But then why were you sitting so long?
But the thing is that your lordship will kindly see. The
Sir, show cause notice was issued in April. He has submitted his reply in May 2021.
May 2021.
And you issued hearing notice in February 23.
May 2021, thereafter COVID period is going on. This is the only problem. Otherwise, they should have.
And this COVID period was not there when you filed appeals.
Yes, my lord, your lordship, we have, but your lordship.
And you filed control delay.
And we have virtual hearing. When we have
Supreme Court,
when we have afforded virtual hearing, they have refused to appear.
No,
my lord, your lordship will kindly.
No hearing, my lord. He should not mislead the court like
this case, my lord.
That
not come.
There is no hearing given us.
File your affidavit.
Yes, I can file.
You file your affidavit.
I will file my affidavit, my lord.
No, in the writ petition. He will restore the writ petition. In the writ petition, you file your affidavit.
My lord, your lordship will kindly see. There is no such point of 5 years, my lord. Kindly see.
It is there in the writ petition.
Now,
the learned judge has not seen, so he will not see.
Learned judge has directed to participate.
My lord,
and thereafter, my lord, when
he has questioned your jurisdiction.
Yes.
Prima
Point A
facie-
itself is without. Yes,
Yes,
sorry, sorry.
Prima facie, you will have to satisfy the court that you are within limitation.
Yes.
We need not go into disputed questions. Going by the dates, the period where the offense is committed, what was your normal period of limitation? What is your extended period? Post extended period, if you had issued show cause, it's good ground to quash the proceedings. We have quashed it.
Then your lordship kindly direct to hear the matter within a certain period, my lord.
The writ petition, this intra-court appeal by the writ petitioner is directed against the order dated 18/5/2023 in WPA 8791 of 2023, by which the challenge to the show cause notice dated 27th April 2021 was rejected. It is seen that the appellant has raised the question of jurisdiction of the authority to issue the show cause notice beyond the extended period of limitation. This being a jurisdictional issue, it will be well open to the writ court to consider the same and take a decision. What has been, the Hon'ble Supreme Court has held that when there is a jurisdictional error, a writ is maintainable. And the writ court will refuse to entertain a writ petition when the assessee seeks to challenge an order on disputed questions of fact. Equally, a writ petition is maintainable when a show cause notice has been issued by an incompetent authority or when there is violation of principles of natural justice. Therefore, it is required to be seen in the writ proceedings as to whether the show cause notice was issued within the period of limitation, for which disputed questions of fact need not be gone into. Therefore, we are of the view that the writ petition should be heard and decided on merits on the question of the jurisdiction of the officer to issue the show cause notice. Therefore, we are inclined to restore the writ petition to the file of the court, file of the learned writ court, to be heard and decided on merits after affidavit is filed by the respondent. In the result, the appeal is allowed, the order passed in the writ petition is set aside, and the writ petition is restored to the file of the learned single bench. The respondent department is directed to file their affidavit in opposition within 4 weeks from date and reply, if any, within 2 weeks thereafter. And the registry is directed to list the matter before the appropriate bench after 6 weeks.
My only request is, my lord, let the demand be stayed in the meanwhile.
In the
We have
meantime,
not adjudicated the matter, my lord. How the demand is raised?
yes.
So on the basis of so called notice.
No, they won't. Next,
Raise the.
Serial number,
that's all. Last line. Mr. Sharaf is taking a chance.
No, Namtan.
Next,
serial number 16.
what is 16?
No, I'm not responding.
16 is, my lord, where the provisional attachment of cash credit account was done. But the learned single judge decided.
You seek for lifting the attachment.
Now, my lord,
No,
the
my
final
lord,
order has been passed.
my
My
lord-
instruction is that my final order passed under my DRC 07 passed, my lord. My lord, we have
My
to
lord,
brought before your
my
lordship,
lord,
my lord.
I am challenged, I have not challenged the assessment order, my lord. But the issue is that my provisional attachment of cash credit account has been done.
No,
The
if
cash credit account, my lord, cannot be attached.
you withdraw this and you challenge the final order.
No, my lord, it is not the final order which I have challenged, my lord, by way of this writ
But
petition.
final order has been passed. Then there should be some observation with regard to they would have swiped off your account now.
No, my lord, the difficulty is that my cash credit
The
account,
attachment would have matured into a recovery. This becomes infructuous. You find out. It
my
is,
lord, then kindly keep it on next Friday. I am not aware whether.
at the request of the learned advocates also. You mark the Devashish's appearance also. Next week, next.
Serial number 17.
My lord, I beg to appear for the appellant.
What is this?
My lord, in this matter, my lord, bank attachment.
Bank attachment.
Yes, my lord.
Why they attached it?
They attach, my lord, we are.
Because you didn't pay taxes.
No, my lord. Actually, no tax is payable. I will show your lordship. Because of third party uploaded wrongly data, my lord. That is why I have no dispute in my books of accounts here. My lord, may I submit?
But the attachment would have lapsed by now.
No, my lord. This is not attachment. Recovery notice. Sorry, I stand corrected, my lord. Section 79 notice. GRC 03. Ex parte adjudication order. 13.
You file an appeal.
No, my lord.
You file an appeal.
My lord, I will show your lordship.
No, no, no.
Several stages, my lord, natural justice violation. And actually, no tax is payable me, my lord, because my lord, I will.
That is a disputed question. That's a dispute.
My lord, next Friday, my lord, next Friday.
No, no. This intra-court.
My lord, I have kindly allow me, my lord, submit.
All right. Please
My lord,
wait, sir.
my lord, my lord. Fine. My lord, may I submit orally first only for 2 minutes, my lord. My lord, we are challenging.
The order was passed on 11th of March 2022.
Yes, my lord. Yes, yes.
2023, you filed.
Yes,
it.
yes. I will show your lordship.
We will save you on limitation. You file an appeal.
My lord, if lordship, only 2-3 minutes, my lord. Only 2-3 minutes. First oral submission, my lord. They uploaded the notices in the online portal in view notice section. This is the main dashboard. For other case, this year not another year, and I have complied for return defaulter. But in this case, my lord, they uploaded notice in the additional portion. That is why I missed, and they passed expiry order. That's the first thing. Second thing is that, my lord, they directly issued show cause notice. They cannot, because there are several processes, my lord. Section 61 and rule 99 says that before issuance of show cause notice under section 74, there is a process for issuance of GST SMNT 10, giving 30 days time. That was not done. And another point, my lord.
But how were you operating your business for over 1 year?
No, actually at that time not at us. No, at us only on 9th March 2022, my lord. Bank account at us. Sorry, 2023. And at that point,
Order was passed on 11th March.
yes, my lord. I'll tell your lordship. That is why, my lord. I'm first placing short point, my lord. This is the second point, my lord. And third point, my lord. They relied in the show cause notice, non-speaking, because no names there, no allegation. And in the order, they say the name of Tontujo.
Now recovery notice has been issued.
Yes, my lord.
We will stay the recovery notice for 2 weeks. You file an appeal.
And my lord, in that case, my lord, they excess recovered, my lord, 20.
That refund and all, recredit and
Pre-deposit, my lord, pre-deposit may be treated from that amount, my lord, because the electronic credit ledger, my lord, 27 lakh.
You have swiped it off from his electronic credit ledger.
Some amount he is saying.
So that amount may be set off towards
as a pre-deposit.
10%.
10%.
Yes, my lord.
10%.
In two cases, my lord, both cases, there are 17 and 18, my lord. And only disputed tax. Delay may be
17 and
controlled, my
18 common order. We have heard so and so. These appeals have been filed against the orders passed in the writ petition, which were dismissed by the learned single bench. The orders impugned in the writ petition were orders passed under section 74 of the WBGST Act 2017. Admittedly, the said order is an appealable order. And the court also taking note of the fact
My lord,
that
only
the writ petition was filed.
My lord, sorry to interfere, my lord. Only one clarification, my lord. The delay was beyond condonable period. It was not within the condonable period. It's a Supreme Court seeing enterprise judgment is there.
You hear us? What did I say? That the writ petition was preferred or filed much after the period of limitation for filing the appeal. That too beyond the condonable time period, declined to interfere with the order passed under section 74 of the Act. While dismissing the writ petition, the learned writ court has held that it will be open to the appellant to avail the statutory remedy available under the Act. The main ground on which the order passed under section 74 of the Act was challenged was on the ground of violation of principles of natural justice. According to the appellant, the show cause notice was uploaded in a different portal, portal, and the appellant had no knowledge of the same. That apart, the show cause notice also bereft of particulars, and therefore it is submitted that the very initiation of proceedings itself is not in accordance with law. In our considered view, since the strike out that. Though the orders which were impugned in the writ petition were passed in March 2022, The orders of the notices for recovery were issued only in the year March 2023. Thus, considering the peculiar facts and circumstances of the case, we are of the view that liberty can be granted to the appellant to file a statutory appeal, more so when certain sums of money have already been recovered by the department from the electronic cash ledger.
27,59,151.
Cash ledger, full stop. In the result, the appeals are disposed of by directing the appellant to file a statutory appeal before the first appellate authority, and if the same is filed within a period of 15 days from the date of receipt of the server copy of this order, the appeal shall be entertained without rejecting the same on the ground of limitation. The pre-deposit amount which the appellants have to make shall be adjusted from and out of the amount already recovered
and
from the appellant by way of recovery from the electronic cash ledger. The balance amount which was recovered from the appellant shall abide by the orders that may be passed by the appellate authority in the appeal to be filed by the appellant in terms of the above direction.
Bank garnishing may be lifted, my lord.
If the appellant files a statutory appeal within the period stipulated by this order, the attachment of the appellant's bank account shall be lifted.
My lord, may I request one thing, my lord, because 27 lakhs, 59 lakhs, my lord, and my tax is in one case 4.29 lakhs and in another case 2.84 lakhs.
That will be asserted, my lord. Your lordship, I kindly record, my lord, my objection to after his contention, my lord, because that portal, my lord, will always be there in the portal.
No, the portal is uploaded violation principle. Mr. T.M. Siddiqui, learned counsel appearing for the state, would vehemently contend that the submission made by the learned advocate for the appellant is incorrect, and all information was provided to the assessee.
And my lord, all the points, my lord, in the writ petition may be
needless to state, last line, that the appellant would be entitled to canvass all grounds which have been raised in the writ petition. Next, 19.
I'm
Number 19.
Similar. Same
order.
17, 18, same order.
Same.
Common order.
And date is different, my lord. In second order dated, my lord, in the second case, 5th December 2022.
That is why we have not mentioned about the date of the order.
Oh, lordship.
Only we said 74 order.
Lordship, I'm grateful.
19.
In this matter, I am appearing, your lordship passed the similar order as item number 15. Item 15.
In this, so the question of jurisdiction was raised and without adverting to anything, and the writ court had dismissed the writ petition, my lord. The so-called notice came in 2020. Reply was filed immediately in February 2021, which is recorded. Even the impugned order also recorded that the question of jurisdiction was there. They should have come immediately, but the hearing notice came in 2023 January. So almost similar facts, and in fact, the additional fact is there. They have no jurisdiction because the main question is the electricity, which is a goods. And
that will be decided in the merits, my lord. Your lordship kindly pass the similar order and set aside the order.
These matters, you will have to make a distinction before the writ court, saying that give me a short time, I will demonstrate
everything.
Limitation issue.
My lord.
Next time you request the court, give me 2 weeks time, I will come on.
Today I have also mentioned before your lordship for filing appeal in this regard, my lord, because there is
because there are adverse observation even against the officer also.
Against me.
So your appeal is numbered?
My appeal has not been numbered. I have preferred the appeal, my lord. This is ready.
We can take it in days list.
Yes, my lord. By
it can be treated on
you number it.
Yes.
We'll take it in the days list.
Yes.
No, because it should be a common order, challenging the same order.
Memo.
Supplementary list you made. We make supplementary list. It will be a common order in both.
Yes.
These intra-court appeals have been preferred by the writ petitioner, assessee, as well as the department. Agreed by the order passed in the writ petition dated 5/6/2023. The appellant assessee had challenged the show cause notice dated 23rd December 2020, issued under section 73 of the Finance Act 1994, read with section 174 of the CGST Act 2017. The learned writ court has dismissed the writ petition on the ground that the petitioner has approached the writ court with after a lapse of 2 years and 4 months from issuance of the show cause notice. It is submitted by Mr. Mittal, learned advocate appearing for the appellant, that though the show cause notice was issued on 23rd December 2020 and reply was filed on 5th February 2021, questioning the jurisdiction of the authority as a preliminary objection, no action was taken by the authorities to adjudicate the show cause notice. Since the assessee contended that the show cause notice is without jurisdiction, suffers from a jurisdictional error, the same was challenged in the writ petition. It has been held by the Honorable Supreme Court that the bar of entertaining a writ petition when there is a statutory remedy available is not an absolute bar. And the Honorable Supreme Court has carved out certain exceptions as to when under what circumstances a writ can be entertained challenging a show cause notice. One such exception which was drawn is when the jurisdiction of the authority is questioned. Precisely in the instant case, the assessee has questioned the jurisdiction of the authority. Therefore, the said issue can be considered in a writ proceedings, however, making it clear that disputed questions of fact cannot be adjudicated while considering the jurisdictional issue. Therefore, we are of the view that the writ petition should be heard and decided on merits. Then what is your appeal grounds?
My appeal grounds is the observation of the honorable single judge, my lord.
What is your justification?
I have come with the honorable court has directed to take action, direct the chief commissioner to take action against.
What is your commissioner saying for the delay?
Well, commissioner says that when there is the period of within period we have issued the show cause notice, time to adjudicate 6 months, and when it is beyond 5 years, my lord, then the period is 1 year. Adjudication period is 1 year. But here
you show your grounds.
Yes, my lord. Kindly see.
The revenue, please take notes. The revenue is on appeal against the penultimate portion of the order passed in the writ petition, whereby the learned writ court has directed, has made certain observations against the commissioner of CGST and CX Kolkata, South Commissionerate, and directed a copy of the order be forwarded to the chief commissioner to fix responsibility for the lapse in concluding the impugned proceedings. It is submitted by Mr. Meti, learned senior standing counsel for the revenue, that
my lord, ground number 3, 4, and 5.
That the time limit under the Central Excise Act 1944 for adjudication is 6 months in normal cases where the normal period of limitation for issuance of show cause notice is invoked, and in the light of the language in section 11 capital A within bracket 11 of the Central Excise Act, and in section 73 within bracket 4 capital B of the Finance Act 1994, the words where it is possible to do so within inverted comma should be construed as directory and not mandatory.
But don't say in all these things because that is also Delhi High Court held that the 1 year is mandatory, and
the department will further contend that in terms of section 73 within bracket 4 capital B, of the Finance Act 1994, comma, there is a time limit of 6 months from the date of issuance of notice for determining the amount of service tax due in cases falling under subsection 1, and within 1 year from the date of notice where it's possible to do so in respect of cases falling under proviso to subsection 1 or proviso to subsection 4 capital A. It is submitted by Mr. Mittal that there are decisions of the High Court of Delhi which have held that, which have interpreted the words where it is possible to do so within inverted comma to be mandatory and not directory. In any event, this is an arguable issue, and therefore we are of the view that at this juncture, no adverse observations need to be made against the Commissioner of CGST, Kolkata South Commissionerate. Therefore, that portion of the order passed by the learned writ court is required to be set aside. In the result, the appeals filed by the assessee and the department are allowed, and the order passed in the writ petition is set aside, and the writ petition is restored to the file of the learned writ court with a direction to the respondent department to file their affidavit in opposition within 3 weeks from date of receipt of the server copy of this order, and reply if any within a period of 2 weeks thereafter, and let the writ petition be, and the registry is directed to list the writ petition before the appropriate bench after a period of 5 weeks.
Grateful. My lord, serial number 8 and 9 may be quoted the recent decision of the on jurisdictional issue.
That you,
the Supreme Court. No, my lord, only
no,
on the
we
writ.
know. It is his argument. So that is good.
No, my lord, I'm not on saying. I'm saying only on the writ is maintainable on the jurisdiction of the writ 2023
All right, you-
judgments. Serial number 8 and 9.
Mr. Mittal,
Serial number
to-
8 and 9.
To buttress, Mr. Mittal, to buttress his submission that writ petition is maintainable, place reliance on the decision of the Honorable Supreme Court in Madak, MAGADH Sugar and Energy Limited versus State of Bihar, 2021 SEC Online SC 891, and the decision of the Honorable Supreme Court in Godrej Sara Lee Limited versus Excise and Taxation Officer 2023 SEC Online SC 95. This you insert in between, sir. You return
Great.
this.
Grateful, my.
Yes, sir. Now we'll take up. Yes. Supplementary list. Yes.
Appellate side, supplementary list, serial number 1.
Meet please, your lordship.
Yes, sir.
Lordship, I'm being led by Mr. Guru Krishna Kumar. Lordship, he's appearing virtually, Lordship.
Yes, Mr. Krishna.
Lord, I'm appealing for the state of West Bengal in this matter. Only one thing just to inform to you, Lord. Lord, just now we have been served with the copies of the.
Now, their apprehension is only this. The time limit for filing nominations is thoroughly inadequate. That's what they say. First point. Second point they say is place of filing nomination.
Yes. Lord, may I, in short, very shortly, Lord, without, I have not got the chances, scope rather, I was doing on matter. Lord, see, these are the contentions. Whether the mechanism which has been fixed by the act itself can be overlooked and court can give a directions or not. These questions in 2008 Panchayat election, a division bench has given some answer. Against that matter went up to Supreme Court. Just from the memory I am telling you, exactly, I have forgotten also. But there I had a privilege to argue all these points. But Supreme Court has, in that case, has very categorically said that the once notification has been declared, firstly, no interference, your lordship knows that judgment. Second, the mechanism, whether can be interfered with by the court or not. But these are the points are there. What I am suggesting, just a minute, sir. Can I allow me to speak for 2 minutes? Then you will speak. You speak here, you will speak there, no problem. The what I am suggesting, rather I am praying before Lords. The points which have come to your Lords, Even can be considered on Monday even.
No, we want a response from the election commission.
No,
Malad.
this is all right.
First of all, my lord, what the state has the stake, my lord, that the first
It is
point.
not
but-
the
my
state
lord,
stake or state stake.
my lord, only thing is that, as your lordship has said, only with regard
me
to
be
the
very clear.
inadequate time,
let me be
inadequate
very
time
clear.
of the nomination being
Listen,
filed.
Mr. Kostov, if you raise voice, I can raise voice before you.
With
You
with
can't-
deepest of respect,
you
I am
can't
not.
match with my voice.
I am not raising voice.
No.
What I am saying, my lord, the
I am very
time is
politely I am
inadequate.
submitting, my lord, what I am submitting only that, my lord, this power, if it is there, this power is also on Monday.
No, we
No, my lord.
hear the state. As of now, there, the prayer sought for, it's identical in both writ petitions.
No, both the two.
They're similar, not identical.
287 you give.
My lord, his petition is WK number.
Mr. Guru Krishna Kumar is appearing in 287.
Yes, my lords.
What is the prayer in that writ petition?
Yes, my lords. Please see the prayer. The first prayer is, please come to page 42, my lords.
That's not his prayer.
43.
42 at 43, my lords.
44.
Yes. Quash the notification.
Only 5 days to submit the nomination.
That's correct, my lords. By allowing only 5 days to submit nomination papers for the upcoming Gram Panchayat elections to be held on 8 July. Then, my lords, appointment, of course, of retired judge to oversee, my lords, the conduct of the election so that there is a free and fair and transparent, peaceful election. Then, my lords, how the prospective candidates must be permitted, my lords, to file their nominations either in the head office of the respondent situated at Calcutta, or, my lords, in the alternative, allow the filing of their nomination papers online. And then, of course, my lords, central paramilitary forces. Now, each of these prayers, my lords, are really, my lords, in aid of conduct of proper and free and fair elections. Therefore, this is something where, my lord, this honorable court would be eminently justified, my lords, in issuing appropriate directions. And only to supplement the observations felicitously falling from my lords, the notification, my lords, is issued today. And it says the nominations start today at 11 o'clock, as though it's some kind of a race they are doing. 5 days, 2 days in between go away because they are holidays for under the Negotiable Instruments Act. 75,000 seats, my lords, spread all over the state. And, my lords, at 3 levels. It is well nigh impossible, my lords, for persons, my lords, to come and file their nominations. It can't be that, my lords, in matters of this nature, the state really acts in this arbitrary manner where it says suddenly one fine day, in that sense, I issue the notification. And what is the term we are looking at, my lords? We are looking at the end of July, end of August, when, my lords, the term will get over and new panchayats will have to come into place. If that be so, my lords, what is the hurry for the notification to be issued today and saying from today it will start and by Wednesday it will get over? Where clearly, my lords, there's an advantage which is available for one section, which is not available for, my lords, the other section. So this is one of the main points, my lords, where I would respectfully submit that the interdict and the interference of this court should be called for.
One second. Who represents?
I appear for the State Election Commission.
Yes.
Now, my lord, so far as this is concerned, of course, my lord, we are taken a little by surprise, but my lord, let me just answer, my lord, the immediacy of the matter.
Yes.
My lord, if your lordship will kindly take 286 and come to, my lord, the list of dates that is an annexure to 286. My lord, that is, my lord, the first of the writ petitions.
Page.
My lord, it is the list of dates, my lord, right after, my lord, the service nature. My lord, there's a list of dates, my lord, that is a part of the writ petition.
Yes.
My lord, kindly see, my lord, let's say that they had made a representation. My lord, your lordships have the list of dates. My lord, your lordship will find that, my lord, the representation was made with regard to, my lord, the grievances that have now been highlighted in the writ petition on 24th April 2023. Now, my lord, so, my lord, they were aware that, my lord, the election is in the offing. Now, my lord, kindly see, now, my lord, 8 June notification, 9 June notification, and then kindly see. My lord, the last date for filing nominations is under 43(1)(a), my lord, on 15th June 2023. So, my lord, I have, of course, not been able to take instructions except to the extent that, my lord, this is, my lord, the normal time period that was allowed on previous occasions also for filing nominations. But, my lord, if the nomination date has to be extended, it can be done even on Monday after, my lord, receive instructions. Because, my lord, we have not been able to do that. Then, my lord, kindly see,
my lord, the dates, my lord, can be now, my lord, pushed back if your lordships, my lord, are so inclined at the end of the day, because, my lord, ultimately, my lord, 8th July is, my lord, the date, my lord, on which poll shall be taken under 43(1). No, my lord, there is no challenge to that. So, my lord, the immediate, my lord, say they want a free and fair.
Their apprehension is giving, taking note of whatever has happened in the past. And the large number of the electorate is so big, this time is inadequate. And of course, they need other protections, which the election commission can address.
Well, that,
in fact, when they mention the matter, even for bar association elections, CCTV, videographing is.
well, that is now, my lord, standard procedure.
Standard.
Now,
And
so, my lord,
here, all proceedings are recorded.
that
So
is not.
when they mentioned in the morning, they.
My lord, that is the
That, my lord,
standard procedure
in
which
the
is
election.
prescribed.
Wait, sir, wait, sir.
My
If
lord,
you are in such a hurry,
Man,
you may
man.
go elsewhere and come
My lord,
back.
my lord, there are two stages. One is the stage of filing nominations.
Ah.
Now, my lord, if your lordship, my lord, I shall, my lord, have to look into, my lord, the rules and what is the
No,
prescription.
everything can be videographed, sir. Now,
Yes, yes.
technology is so very, user friendly.
My lord, that has been directed previously, and, my lord, that is the practice followed.
That you need to put in place without a direction.
That is right, my lord. I
Because
don't.
election commission is a body, you're an independent body.
Yes.
And your endeavor is free and fair polls.
Absolutely.
That's the bottom line.
Absolutely.
So whatever you need to do, all proactive steps, I will do this, I will do that, I will do this. You come out with a checklist. And this prima facie we feel, subject to what senior counsel may submit on the next hearing, prima facie we feel that's a very short. And it's.
Well, I will take instructions. Well, kindly keep it on Monday. If the time has to be extended, it can be extended even on Monday.
Everything should be pushed back. If 8th July will be there, but August the term comes to an end.
No.
Well,
August.
the elected.
May I just make a
No, present elected body's term, when does it come to an end?
Well, election, that will be, it will start from August. Just before that, the rider is there. After being elected, they need a training under the statute for a period of 1 month. Only after that.
Special officer can take that, sir. Executive officer of the panchayat
No,
can run the panchayat.
that's a different part. Number, if your lordship just permit. In 2000, why this July? In the 2018, the election process was challenged. 18. Election was allowed to be continued by the Supreme Court by an interim order, but no result should be published. Ultimately, in the month of July, matter was hard, and ultimately in the month of July, the Honorable Supreme Court has said no, result would be declared. If anybody is any grievance, so far 20,000 seats are concerned, they can go and file the appropriate proceeding. Nobody has done it. Therefore, the July is the date of the announcement of the election result. There were 5 years under the Constitution. The July, naturally, July would be the election. It is every political party should know about it. I can tell this much. If he doesn't know, then that's a different
It's
thing.
not an universal rule, sir. There have been directions issued by several high courts where states have not conducted election for local bodies for years together.
Correct. Where the election has not been
And the
conducted.
executive officers.
Lord,
have been
where
running
the,
panchayats.
my Lord Chief Justice is right, absolutely. Where the, your Lordship is.
I have been party to 3 judgments.
My Lord, your Lordship is absolutely right. Where the election has not been held.
Yes.
But where the election is declared to be held, not.
No, in fact, senior advocate who is appearing also says their objective is not to interdict the election process.
Correct, my lords. I bow down, my lords.
Absolutely.
And they want it to be done in a fair manner with the election.
Well, that election commission, I have nothing to say on that. I have nothing to say on that. What is that? What are the decision would be taken by the election commission? I am only under section 42 of the act.
We will hear this.
That's right. I am all. That is, I am not saying anything about.
There are immediate concerns.
Whether the court's power or the election commission's power or court will substitute its power, I am not concerned about that, Miller.
Your Lordship,
I am
only-
concerned that only one thing that the notification has not been challenged in any of the writ proceeding.
Yes.
Yes. They made it.
Our prayer is that.
Only constraint, my lord.
Suppose you challenge a notification, they may raise an objection that Once the election process is commenced, Onuswamy's case.
That's it.
My lord,
How will you get over that?
only, no, my lord, we are not,
You answer the question from
My
the
lord,
court. How will you get over that? If you challenge the election notification, if you restrict the
we
challenge.
don't want to stand in the way of the election, my lord.
You
We
challenge-
want certain modifications to be, my lord, only one pragmatic consideration. As of now, Rani Nagar, there is a place called Rani Nagar in the district of Murshidabad. The block office has been surrounded by goons supported by the ruling dispensation, and the difficulty is that is the reason why we want the nomination to be submitted in the concerned district magistrate office as well as the state election commission office, wherein the person face hindrances. That is the reason why we have come up before this honorable with slightest of this modification.
In
We do not
specified
want
spot-
to stand in the way of the election. We want to make it clear, my lord. We don't want to stand in the way. We want the elections to be held.
My lord, the
And my lord,
immediate-
from the Charter of Demands, it is clear that in our petition in 286, from the Charter of Demands, point number 1 that was made is that we wanted election to be conducted within due time. So standing in the way of the elections is not our intention. We want the elections to be violence-free, peaceful, taking lesson from the elections, what had happened in the year 2018.
But prayer B gives a different, slightly different color. Prayer B, you want to set aside the notification. Not in your prayer. So we will grant Monday. we will come
Yes,
back with
well,
the other
only
side.
I had two submissions to make if my lords consider it appropriate, my lords, at this stage. I bow down, my lords, to the observations of the court, my lords, that at the end of the day, the time being what it is, there has to be retuning, my lords, by the election commission. I bow down to my lords' observation, my lords, that they have to volunteer, come forward with ABCD measures, my lords, to see to it that the elections are conducted in the most fair and free manner. And to that extent, my lords, there may not be any necessity for the court itself to really intervene, step in and start issuing directions. That's one part of it, my lords. That's the first stage. Second stage, my lords, second point I want to highlight is this. We are only talking about how the time limit is too inadequate. To that extent, the notification will require, my lords, some kind of a tinkering. And that is something, my lords, which will really not make a difference to the timely conduct of elections and putting in place an elected body by the outer date, my lords. That's the second point I wanted to highlight. The third point is, my lords, on the other aspects with regard to, my lords, law and order, provision of paramilitary services, CCTV footage, the need, my lords, to give some kind of liberty, my lords, to candidates to have the option, my lords, to file, my lords, their nominations through various other modes other than what is normally envisaged under the Act and the rules, my lords. And that is for compelling factual reasons, my lords, which are supported by past instances, including of proceedings before this honorable court. So I bow down to my lords, to the extent that my lords have called upon the election commission, my lords, to come back with a clear proposal with regard to the date of filing of the nominations to start with, my lords, and then we'll make good our submissions on the other prayers, my lords.
Yes.
I reiterate my submission, my lords, that we are looking at interference of the court, my lords, for furthering the election process in a manner by which, my lords, the elections that is conducted will be free and fair constitutionally, my lords. That's really what we are looking at, my lords.
Well, at the first instance, my lord, your lordships have pointed out, my lord, it appears that, my lord, the time for filing nominations is then inadequate. We'll take instructions and, my lord, come back to your lordship on Monday. The
Now,
rest of, my lord, the direction.
What is the procedure for filing nomination? Is it online or?
No online.
That is not, my lord,
If I am assisting your lordship's court, because possibly he is not aware.
You can't be assisting the election.
No, assisting your lordship's court. I have said
that is the
no.
No, my
You
lord,
read, I have said I am assisting your lordship's court. My lord, this is now all our videography. Your lordships can rehear that what I have said.
Country is
Right?
watching.
My lord, kindly see why I am trying to assist. There, the Calcutta High Court division bench has taken a different decision. My lord, divorce the rules. I am just on. The electronic version, electronic form was substituted by the division bench. The Supreme Court has considered that. That's the reason I'm trying to assist your lordships. For the reasons indicated, we allow them and set aside the impugned judgment. An order of the Calcutta High Court directing the acceptance of nominations in the electronic form, so and so. Why? Rules have been provided. Rules makes the provisions. File the nomination super Gram Panchayat is concerned to the BDO. File the nomination super the Panchayat Samiti is concerned to the SDO.
You should have amended the rule by now.
No, I have not amended.
The rule should have been amended. Now e-filing has been done.
Rule has not been challenged.
No, the rule has not been challenged. See, in the present times, you should be abreast with the technology. So why has he
My lord,
said, no, he is not confident of going and filing a nomination before a block officer. He says, I will go before the
District
state
magistrate.
election commission or the district magistrate. Why? If it is been made online, no issue.
No, my lord, this online process has not been prescribed in the rules
It
itself.
should have been.
My lord, let it be first part done by the Chief Election Commissioner under the Election Act. There's no difficulty.
No, your
Lord, Parliament is not doing.
your state election commission.
Parliament is not doing. Parliament is not doing all over the. Not a single state has done it.
Your state, let you set an example. You do it.
My lord,
You set an example.
my lord, that's a different approach. But the Parliament has not done it. Who has come, my lord?
No, in fact,
My lord, who has come before, my lord?
no, Calcutta High Court has got many fuss, which have never been done by other high courts. So there have been many fuss, and you can also take a proactive stand in this and say, yes, I will go.
There is a
online.
distance between Calcutta High Court and state government.
Actually, if it's going to be online, things become very easy. Scrutiny is absolutely seamless. Now, people who are applying for group, I don't know here what are the different groups in the service commission. Let us assume a non-gazetted post. The basic education qualification is pass in 10th standard or pass in 12th standard. Those applications are uploaded. Even at that level, 10th standard, 8th standard pass are uploaded. Everything is online now. So therefore, we need not be allergic to technology.
No, not allergic. My lord,
Suppose on scrutiny, there is a query raised to the intending candidate. So he replies online. There is a redressal mechanism where which he appears before the returning officer saying that, sir, this is my credential. This is my property statement. You please verify. Probably uploaded document may not be there. So let us say if 100 nominations are filed, 80 or 90 nominations, there will be no problem. Seamlessly, it can be scrutinized. There are 10 nominations may require some clarification. See, that's how you take an election process. So that's what our endeavor to Mr. Saha is to impress upon the commission.
May I just, with the queries which have been made, can I just, this is the approach has to be taken by the legislature, not by state
We are
itself.
thinking aloud.
That's correct, absolutely
So
correct.
we are not aware.
No, absolutely
Other-
correct.
I am not
My
aware.
lord, I would have been happy that your lordships kindly make this suggestion to the central government
Yes,
and
yes,
let them make the let them make the amendments.
yes,
Where the BJP ruling government is there, let them make these amendments. Let them be the first runner in the country.
Lords, I had one submission to make on this point, if I may, my lords.
Let us come back, my lord. Let us come back with my lord instructions. I followed what your lordship.
We'll hear you on Monday.
Very well.
Okay, get back with instructions.
My lord, only in the
These
interim stage, my lord, if the nominations could be filed before the district magistrate or before the state election commission.
These
if your lordship wishes.
petitions have been filed as public interest litigations concerning the forthcoming election to the panchayats in the state of West Bengal. The matter was mentioned before this court at 10:30 today, and considering the urgency, leave was granted to file the writ petition, and the same was directed to be taken before at around 12 noon. The respondents have been served, and in particular, the West Bengal State Election Commission has also been served and represented by Mr. Jishnu Sahal and a senior advocate. The prayer in WP 286 of 2023 is for issuance of writ of mandamus to set aside the notification issued by the State Election Commission notifying the elections for the panchayats and issue the same afresh after implementation of the demands made by the writ petitioner, by the representation dated
24th April.
24th April 2023. The petitioner also seeks for deployment of central forces from the date of filing nomination till the declaration of result, semicolon, for a direction upon the election commissioner, comma, West Bengal State Election Commission to ensure that the candidates are permitted to file their nomination before the state election commissioner and/or concerned district magistrate of the concerned district and for certain other interim reliefs. In WP number 287 of 2023, the petitioner seeks for
Page 45.
issuance of a writ of certiorari to quash the decision arrived at by the respondent authorities in allowing only 5 days to submit nomination papers for the upcoming Gram Panchayat elections to be held on 8th July 2023, semicolon, to appoint a honorable retired judge of this court as special officer / observer to ensure conduct of a free, fair, and transparent and peaceful election to the 3-tier Gram Panchayats in the state of West Bengal. Semicolon, to allow the prospective candidates to file their nominations in the head office of the head office of the West Bengal State Election Commission. Or in the alternative, allow filing of their nomination online. Semicolon, provide adequate number of central paramilitary forces immediately for conduct of free and fair elections. Semicolon, to extend the time for filing of nomination papers by at least 12 days from the date of notification of election to complete the process of filing of nomination. And to comply with the directions issued by this court, issued in WPA within bracket P number 611 of 2022, dated 28th March 2023, semicolon, to install CCTV cameras at all police stations. Semicolon, to ensure simultaneous counting of polling, simultaneous counting of the votes for the Gram Panchayats, Panchayat Samitis, as well as Zilla Parishads under the superintendence of a special officer. Semicolon, to prohibit the election commission from using any contractual workers and/or civic volunteers and/or teachers and non-teaching staff whose issue is sub judice by not giving any election duty. Semicolon, to direct the election commission to ensure imposition of prohibitory orders under section 144 CRPC within 1 kilometer radius of various counting stations and other interim reliefs. We have elaborately heard the Mr. Guru Krishna Kumar, learned senior advocate, appearing for the petitioner in WPA 287 of 2023. Mr. So-and-so, learned advocate, appearing for the petitioner in 286 of 2023. Mr. Jisnu Saha, learned senior advocate, appearing for the State Election Commission. Mr. Kalyan Bandapodhyay, learned senior advocate, appearing for the state of West Bengal, and other learned advocates who are present in court. From the varied prayers sought for in both the writ petitions, the court is able to decipher that the object of the writ petition is not to stall the elections nor interdict the election process. This is presumable because the petitioners are aware of the legal position in this regard. the endeavor of the petitioner appears to be to ensure free and fair elections. Therefore, the court is required to consider as to how best the same can be ensured so that not only the nominations are filed in a peaceful manner, the elections are also conducted in a fair and peaceful manner, and the results are declared. We are informed that the nominations have to be filed in physical format. Full stop. It is submitted by learned senior advocate Mr. Bandyopadhyay that there is a decision of the Honorable Supreme Court which has set aside the order passed by this court directing court in the elections conducted during 2018, directing filing of nominations electronically. Be that as it may, the endeavor of the State Election Commission should be that there should be fair and free elections, and the electorate should have confidence in the Election Commission that all will be done well so that they can exercise their franchise in a peaceful manner and elect their desired representative. Prima facie, we are of the view that the time limit fixed in the notification is inadequate. The notification has been uploaded / published today, 9th June 2023, and filing of nominations would start from today. This, in our view, would be would appear to be hurrying up the process, which needs to be reconsidered by the State Election Commission. We are also informed that the term of office of the present elected bodies of all the panchayats at the 3 levels is to come to an end in August 2023. Bearing this in mind, the State Election Commission can fix reasonable time to the prospective candidates to file their nominations, because it is insisted that nominations have to be filed in physical form. The other concern which is expressed is with regard to the safety of the candidates who seek to file their nominations. It is the uniform representation of the petitioners that they seek for directions to file the nominations before the district magistrates of the concerned district or the State Election Commission. It is not clear as to what is the apprehension in the minds of the prospective candidates or that of the petitioners. It is said that past instances does not give them confidence to file the nomination before the concerned block officer of the panchayat concerned. This issue can also be examined by the State Election Commission. So far as ensuring free and fair polls, it goes without saying that right from the stage of filing of nomination till the counting and publishing of the results, the entire process should be videographed, and the safety of and the security of the video footages have to be protected, and the duty lies with the State Election Commission in this regard. With regard to deployment of central forces, if in the opinion of the state government, it would augur well to seek for deployment of central forces so that the state police force can work in tandem with the central force so that so as to avert any law and order situation. In this regard, we stand by for the response from the state of West Bengal. The other concerns which have been expressed in the writ petition shall also be taken note of by the State Election Commission, and their views in the matter shall be filed in the form of a report before this court on Monday, that is 12th, on 12th June 2023. List the matter on 12th June 2023. We stand by for the response of the state election
Anytime.
in this regard.
Any
not
suggested times?
the government of West Bengal.
Excel also submit.
Mr. Kumar, any suggested time for Monday?
Election. Yes, sir. So we'll hear this matter once again on Monday.
May I
But I
pray
was
for an
just
urgent
asking-
copy of my lord the order, so that
Yes.
my lord we may immediately take steps. My lord,
By what is the server copy? We'll do one thing. Probably by 3 p.m. they will.
I'm grateful.
Just
We also need it also.
State get.
But only to inform your lordship, my lord. Since I know that municipal matters, the Chief Justice Prakash Srivastava, same prayer has been dismissed with giving reasons regarding the CIS, CV, Central Forces, etc.
That is,
No.
we'll stand.
No,
Lord,
Lord,
better-
perhaps-
Can I
Lord,
suggest
perhaps
one
liberty
thing,
was
Lord?
granted, Lord, that is not correct.
Can I suggest one thing to my lord?
In that, but I have annexed that order, it is not dismissed. I have
All
annexed
right,
that,
my lord, can I suggest one thing?
not dismissed.
Since your lordships have taken so much, can let them come up, at least the names of all the candidates. On Monday, give the list here.
How does the state know that?
Let them say.
How does the state know that?
Let them say whether
How
I
does
can
the
do
state
it or
know
not.
all this, Lord?
I
How
can
does the
do it
state
or
know all
not, I
this?
know.
State is not conducting the election. The election commission is keeping quiet.
When you have come to the court, you must
It is not-
show.
Yes.
After all, leaders of the political parties have come. Let them come up with the names. At least 50% names. Let us understand.
Oh, election commission will take care. Now, as per the constitutional scheme.
Yes.
As per,
Yes,
they are an independent body.
Yes, of
And he has got power to transfer your officers.
Yes.
He has got power to transfer your officers.
Yes. Everything like Chief Election Commissioner. All powers. I
So
understand.
if
I mean, he is having the power to remove me from tomorrow to argue. He is having the power.
that power Mr. Saha won't exercise, that he won't exercise. He knows, they know better, sir.
Yes, I know.
We'll come back, my lord.
Lord, Monday matter will retain its position, Lord.
No,
Effectively-
on top, sir. On top of everything.
My lord, effectively,
Top of the High Court.
effectively, what has happened? There's another one publicly interest litigation which may come up on Monday. It has become infructuous. That in that PIL, prayer was that why the Honorable Governor is not nominating the name of the Chief Election Commissioner. For 1 month or almost 1 month has
Sir,
kept it pending. Now it has
One
been
more
done.
line. In the prayer sought for in the petition, the petitioner has also sought for appropriate direction not to deploy contractual employees.
Yes.
And badli workers
No civic volunteers.
as election officers or to partake in the election process.
Yes.
My lords had indicated that even in the earlier dictation, my lords, while noting
Lord,
the
one line kindly add, my lord.
And in this regard, we note that a separate public interest litigation has been filed.
Yes.
Wherein certain instructions given by the Chief Election Commissioner have been referred to, wherein there appears to be an embargo for deploying contractual staff in the election process. This aspect also shall be considered by the State Election Commission and be addressed in the report.
My lord, that matter has been directed to appear on Tuesday. So I'll give the number that may appear on Monday also with this matter.
My lord, kindly add one sentence, my lord. I am raising an objection regarding the maintainability of the petition.
Mr. Bandyopadhyay and senior advocate appearing for the state of West Bengal submits that the state is questioning the maintainability of the writ petition. This issue will be considered at the appropriate stage.
The election commission is to file a report regarding the decision.
Yes. Yes, we have changed it.
No, it has gone, yes, it has gone as state response.
No, that we have changed it, not to say.
Well,
My lord,
We'll once again go through before. He's named this. You have named the election commission by name, is it?
In one of the writ petitions.
Which writ petition?
Yes, in my writ petition.
We'll delete it with cost. SLSA, how much? Your client can pay.
I have to pay.
You can pay.
My lord, may
Yes,
have done
287,
Yes,
your
yes.
petition.
Why?
Number 9.
See the name of the respondent number 9.
Yes, we have made him party.
Uh,
We have also
we have
stated
heard-
in the.
We have heard the learned advocate.
Lord, we have taken. upon
Mr.
the
Guru
bias.
Krishna Kumar,
Yes, my lord.
the election commission has been impleted in his personal capacity. This is.
I just saw that, my lord. Yes, I saw that. It's because there's a prayer, my lord, for overseeing. My
Are
lord.
you willing to withdraw? I mean, delete him?
All right, my lord. We will not press that. No, we will delete his name, my lord. We'll do it.
We find that the chief election commissioner, the election commissioner has been implemented by name as the 9th respondent, which in our opinion was uncalled for. The learned senior advocate, Mr. Guru Krishna Kumar, learned senior advocate, appearing for the petitioner on instruction would submit that the 9th respondent is given up and the leave may be granted to correct the cost title. The learned advocate on record for the writ petitioner is permitted to delete the 9th respondent from the array of respondents and the cost title be corrected in the department. Yes, Mr. Vora.
Yes, my lord, may I seek my lord's indulgence to mention this item number 1 in the original site. If my lord is subject to my lord's convenience, can it come up in the afternoon?
But there's a larger bench, my lord, because of. we are having
2:30, we have got a larger bench, sir.
I can wait, my lord. I can take my chance after the larger bench is over if there is time remaining.
Lordship has got a single bench after that. We didn't anticipate this matter.
This was at 12, my lord. No
That
problem.
is why we said 12:45. We didn't know that you are going to
No,
travel,
no issue.
traveling.
No issue, my lord.
Then when will it be convenient for you, sir?
My lord, this is a little urgent. If my lord permit me, virtually I can do it on Monday.
Yes, virtually most welcome, but physically you are more welcome. But weather in Kolkata is not conducive.
Physically on 14th, but otherwise virtually on Monday, whatever is convenient to my lords. Monday, this matter is coming up. This may also take a little time.
Original, sir. Monday 2 p.m.
Monday
My
2
lord,
p.m.
this list will be there.
Yes. Monday 2 p.m. it will come. Either virtual also, there's no problem.
Much obliged, my lord.
Subject to your
Much
convenience.
obliged. Extremely grateful, my lord.
My lord, so all the matters which are listed today will be taken up on Monday. No, my
Which
lord.
is your matter? Your matter.
Two, my lord.
We'll delete that.
No, my lord.
Item number 2, my lord. Mentioning means deletion.
Item number 3 is my matter, my lord. It will be taken up at 2
Yes,
p.m.
1, 2 and 3 will come on Monday.
Much obliged.
There's some urgency if your lordships take it at 2 p.m. today, my lord, because the list says 2 p.m. There's an election matter, my lord. Election.
Cost accountants, let it wait.
My lord, item number
This is
2, my
more
lord.
important. This
I
election.
understand, my lord.
Monday.
In item number 2, I am appealing for the state, my lord. This is my appeal, my lord. She is there, my lord. Can it be taken, my lord, next Friday, my lord? Next Friday, 2 p.m., my lord.
Next Friday.
Next Friday.
All right. Yes. Item number 2, at the request of the learned advocate appearing for the appellant state, he is taking down. List next Friday in the admission list. No, under the same caption, intra-quota. Grateful, Your Lordship.
My lord, I have read the news that one of the Honorable Supreme Court judge has praised your, my lord, Chief Justice at Chennai
Sir, we are
and
on
said
line.
that, okay, I understand.
No, I can say one thing,
But second, I am more happy to hear the second part, which I have not said.
No, while I spoke very high of how my brothers and sisters have accepted me, how all of you have accepted me, and how the senior advocates in High Court at Calcutta prepare their briefs. You see that news.
All right, my lord, I'll check it.
That was very unique. I used to watch when all of you are arguing with their handwritten notes.
Yes, exactly.
So that I have said.
That is the practice, my lord, in Calcutta High Court. That is also practice in Patna High Court. That's also practice in the Odisha High Court. I tell you, lordships, the pleadings, your lordships will find it anywhere. Pleadings of the Eastern region, Calcutta, Patna, and Odisha. I am not much aware about the Madras. But so far, these pleadings of this High Court, my lord, have been considered to be the area, right from the first court to have been considered is the best pleading in the country. And my lord, if just I am giving an example, if suppose any matrimonial matter goes to a Delhi, My lord, pleading itself is the sufficient ground for the divorce.
No, Mr. Ajay Vora is here. Whether he will agree with you, I don't.
Fortunately, I don't appear in divorce matter.
Deep love there is.
Thank you.
But I am happy to hear the second part which I have not said. Praying before the God.
Yes, sir. Thank you, sir.
Much appreciated.
Obliged, my lords, deeply obliged.
Special bench, item number 1.
Most instances, my lord, I have started the proceedings and most of the times, my lord, again, I have a report, my lord. So if your lordship, whenever directs me, my lord, I will hand it.
What was the last order?
Yes, my lord.
Some good news, at least.
I don't know whether it's good news or it's a bad omen. I don't know.
This is called starting with a bang.
Last time, Mr. Amit Das had given one
Yes, my lord.
sealed cover
Yes.
saying that 9 advocates have. That cover is there. Can we open that cover? You show. Yeah. No, this is Commissioner of Police report. Another count.
Advocates, 9 advocates are filed affidavits.
This also you can open.
What is the progress by the Bar Council of India in the meantime?
Yes. Well, so far as Bar Council of India, I don't find.
Somebody was there last time. Somebody was there last
Yes,
time.
Mr. Kankani, Mr. Avinash Kankani had appeared on the last occasion.
They were taking up the exercise of identification also.
May I tell you, Lordship, there are 2 things. So far as Bar Council of West Bengal is concerned, the first direction was on me to furnish to the Bar Council of India the names of the learned advocates who has been identified by the Bar Council of West Bengal. Now, my lord, there seems to me some communication gap. My learned junior went to hand over the names to Mr. Kankani, the learned advocate who was appearing in a sealed cover. Now, he was somehow hesitant to take it. Then he said that, okay, I am texting you the email ID of Bar Council of India. You please send it by email. Now, we thought it fit to take your lordship's direction because we cannot, since your lordship wanted us to give it in a sealed cover.
Yes, his email won't be proper.
Yes, therefore, my lord, we awaited, my lord, your lordship's direction, but we have it over here. Only the names. This is one part of it. The other part is Mr. Anit Das was to furnish the names of the learned advocates to us who had supposedly filed or prepared affidavit. My learned
Today, Mr. Anit Das is not appearing because my lord, just few days before he have the operation of his glaucoma in the left eye, my lord. That's why he's 2 weeks, my lord, need because the doctor has advised him to 2 weeks.
Yes, very good.
Indeed.
He has some eye problem also.
Yes, last occasion.
Because he is very.
There's a black.
Yeah. The court can open the seal and see the names. By that process, it can be expedited. The matter should be settled sooner the better. Now 9 advocates have come forward. Yes. West Bengal has identified some. So some of the people have come forward. But what about the abettors? Yes, that is the more important. Probably the names should be common. The names given by the Advocate General, the Bar Council would be common. We have definite information who are the abettors. But we being judges, we cannot disclose. And some of them are practicing, some of them were practicing, and now more in politics than in practice. So what to do about them? Otherwise, it may so happen that we may ask the central agency to find out. But without finding them out, we shall not close this proceeding.
These are all innocent persons.
Yes, these
Yeah.
9 are really innocent. They have been encouraged to do this.
Lord, I personally, my lord, cannot interfere with the course of justice. This is also, my lord, a
No,
course
no,
of justice, my lord.
There should be somebody who should bail the cat.
Now, there's a report by the Commissioner of Police where one advocate defended saying that we did it for a definite purpose. Kindly identify that advocate and let him appear before the court.
Last order is to that effect. Today,
I have got the report.
some report has been filed by the.
I haven't filed as yet,
Commissioner
my
of
lord. If your
Police.
lordship permits me, I can file it.
এই তো, পরে তো খুঁজছি না।
My lord, bar council.
This is by the advocates. You please.
Absolved. They did nothing.
Basically, there are three issues. First is the affidavit given in sealed cover by 9 advocates. Second is the direction issued to the Bar Council of West Bengal to share information with the Bar Council of India. And third is the report filed by the Commissioner of Police, in which one of the advocates has owned responsibility for printing out posters. We need to see what has to be done. And fourth is the people who have pasted those posters. There are only 4 issues now. So far as the advocates, 9 advocates, we can deal with it now. So sharing of information with the Bar Council of India,
I can do it here and now.
but you are appearing.
My lord, I'm appearing for the part.
No, you received the cover.
I shall, my lord, because on the last occasion, my lord, some gentleman had called me, my lord, just one day before the hearing. So I said, it'll take some time, you send it directly to the bar council.
Actually, we can't share it by email.
My lord, then.
So you,
I
if
will
you want,
take
you take the cover,
I will take.
retain one copy for yourself,
My lord.
you put it in a seal cover and send it to whomever you want.
My
to
lord.
send. That much you do today. And so far as that advocate will see.
Yes.
Please come. Reference may be made to the order dated 25th April. Reference may be made to the order dated 25/4/2023. In the said order, certain directions and observations have been made. We shall deal with the same in seriatim. The first of the observations slash directions, which is required to be considered, is with regard to the affidavit signed by 9 advocates. No, this one. Affidavit, 9 advocates, which was submitted in a sealed cover by the learned counsel, Mr. Amit Das, representing those advocates. The sealed cover was received on the last hearing, but was not opened. Today, the sealed cover is opened, and it is seen that one of the 9 advocates has filed an affidavit tendering unconditional apology on behalf of themselves, on behalf of all the 9 members who are members of the Bar Association. Along with the said affidavit, Annexure A contains the signatures of all the 9 persons. Considering the fact that that all the advocates have realized their responsibility and have tendered unconditional apology, the affidavit is accepted and they are discharged from the proceedings, subject to the condition that they shall not indulge in any such practice in future and shall not come to adverse notice of the court. Full stop. The affidavit shall be resealed in the envelope, and the names of the 9 advocates are not disclosed, are not mentioned in this order to maintain confidentiality. We'll put it in the same cover. You put it same cover, reseal it. 1 second, I'll write it here. See, from whom you are receiving. Simply you collect it and that's also. Simply see. By whom? That will come. This one you reseal. Not open. This one. The next aspect is with regard to the direction which was issued to the West Bengal Bar Council, Bar Council of West Bengal. The Bar Council of West Bengal was directed to furnish the names of lawyers who were identified by them to the Bar Council of India. And both the statutory bodies were directed to make their submissions with regard to the persons who were alleged to have been involved in the incident. Due to certain technical difficulty, the information could not be shared with the Bar Council of India, and accordingly, India earlier.
Sorry.
And we direct the learned advocate appearing for the Bar Council of West Bengal to to hand over the sealed cover to Mr. So-and-so. Mr. Avinash Kankani, learned advocate appearing for the Bar Council of India, who has received the same in court. The learned advocate for the Bar Council of India shall communicate the names to the to their parent body, to the officials of the to the chairman of
Kindly say to the chairman. Chairman is the person.
to the chairman of the Bar Council of India and obtain necessary instructions, and the learned senior advocate for the Bar Council of West Bengal and the and the learned counsel for the Bar Council of India will be heard on the next hearing date. The next aspect is with regard to the persons who had affixed the posters. You have filed an affidavit. That affidavit you take. Deepesh. Yes. You are all there. Very good.
You pharma typically,
This is Abhishek Manna and others. All of them filed individual affidavit. How many of them? 6. 6 of the 6 persons, namely, those names are there already, were identified who have been engaged, who had affixed the posters, and we had issued direction, and they were implemented as contemnors, and they were directed to be present in court. The 6 persons have filed individual affidavits tendering unconditional apology. From the affidavit, it is seen that all of them are presently jobless and and are employed off and on in certain miscellaneous works. And it is stated that on 8th of January 2023, at about 11:15 p.m., through one of their friends, they were informed that they have to reach Howrah Bridge. And at about 11:50 p.m., they reached Howrah Bridge, and a person wearing a mask in his face approached, stating that there is a job for pasting posters. And if they undertake to do the job, they'll be paid a decent amount. The deponents further state that they inquired about the contents of the poster, but the person replied that there is no need to know about it, and the contemnor should be interested only about earning money. The contemnor is stated to have accepted the offer without going through the contents of the poster, and they earned rupees 5,000 for affixing the posters. The contemnors, along with the contemnors, is stated to have reached the Calcutta High Court at around 12:15 a.m. on 9/1/2023 and started pasting the posters and completed the work by 2:20 a.m. on 9/1/2023, and after which all of them went back home. All the contemnors would state they are uneducated persons. They are not in a position to understand the contents of the poster, and they required money for various purposes, and they were tendered unconditional apology. Considering the affidavit filed and taking the averments therein to be True, we accept the apology. No, not we. The unconditional apology tendered by all 6 of them is accepted and they are discharged. This is subject to with a specific condition that they shall not in future accept any engagement for pasting of posters or erection of banners at the instance of any third party. More particularly in the premises of the High Court or in and around Kolkata. In the event the 6 persons violate this condition, they will be dealt with severely.
But one blood correction in and around not only Calcutta, Salt Lake and Newtown.
Yes, Mr.
But Salt Lake and Newtown also included.
Anywhere so in Kolkata, I mean in High Court, Salt Lake, Newtown, or anywhere in Kolkata.
Yes.
There were two cases were lodged. One was under the arrest, another was under the.
They shall face the trial independent of this. That is there.
This direction will consequently the personal appearance of the 6 contemnas is dispensed with. This order shall have no bearing on the criminal cases which have been registered against the 6 persons, which shall be taken to the logical end. Then the other one. You have got a report today also?
Yes.
Let us see that report.
And that was your lordship specific direction, madam. So therefore.
The earlier report also not open, no? Earlier report one more.
Yes, earlier report was opened and Lordship had sealed
It was opened and then again resealed, madam. Report.
Oh, opened and resealed. Now you open this.
This was with regard to madam, the address, I believe, of the person concerned. I think that is.
But he regularly practices here.
I don't have any instruction on that. But I, for my personal experience, and I've not heard about any such name. Constituent superintendent over the language there.
So now we'll implead him and issue notice, let him appear. He is practicing here since January 2013. Mr. Dipnil Banerjee. 6 Old Post Office Road,
Dipnil
first floor,
Banerjee.
Kolkata.
Dipnil বলছে।
Diptesh Banerjee.
দীপ্তেশ না দীপনীল বলছে।
Dipnil.
This is not there.
Yes, sir. Dipnil. DIPNIL. Dipnil Banerjee.
Was in fact nobody. I don't know how this name has come. But he was nobody in the incident.
No. He says one of my chamber is located in residence, other one at 6 Old Post Office Road, first floor, opposite F gate of the Calcutta High Court, and sometimes at the bar station, room number 17. Where is our secretary? Bar station, room number 17. Mr. Dipnil Banerjee. In fact, he has accepted. That was mentioned in the report of the Commissioner of Police. We saw that and we directed further report and they have questioned him. Full details have been given. He has been practicing bar station number, room number 17. Enrollment number is given, Aadhaar card, date of birth.
To our understanding, possibly this man has been made a scapegoat of the incident, and somebody who is the actual abettor he is behind. He is not a name. His name is not come forward.
That I said from the very outset.
Lordship has been saying that from the first date.
That is our understanding that we know that.
And
Let us come forward with the actual
we
information.
are convinced that if the abettors are not brought to book, nothing is going to change.
Well, let Dipnil appear and file an affidavit. He will disclose everything. I think that will be better.
Next para. In terms of the directions issued earlier, the Commissioner of Police Kolkata has filed a report dated 14th May 2023. In the report, from the report it is seen that the advocate whose conduct we had noted in the order dated 25/4/2023 is Mr. Dipnil Banerjee, DIPNIL Banerjee, stated to be practicing in this court and other courts for over from 2013. Along with the report, a statement recorded from Mr. Dipnil Banerjee has been appended, in which he has stated he has stated that that one of his chamber is located at his residence at Howrah, and the other at 6 Old Post Office Road Street, first floor, Kolkata 1, opposite F gate of the Calcutta High Court, and at sometimes he is in the Bar Association, room number 17. In his statement, Mr. Dipnil Banerjee has stated about one Mr. Abhishek, Abhishek Manna, who is his law clerk on temporary basis as per requirement. He would further state that he has paid rupees 5,000 to Abhishek Manna. And he has stated that he knows that Abhishek Manna went to areas adjacent to High Court to affix posters in the night of 8th and 9th January 2023, and the posters contained certain information about the Honorable Judge. For certain questions which were asked, Mr. Abhishek, Mr. Dipnil Banerjee has kept silent. In order to take the matter to the logical end, we deem it appropriate to implead Mr. Dipnil Banerjee and Mr. Abhishek Manna as contemnars in this contempt application. Let notice be issued to Mr. Dipnil Banerjee, son of late Malloy Banerjee. 26/1 Dingshai Para Road, it is there here. Para Road. All right. Implead so-and-so as contemnars, and we direct the Commissioner of Police Kolkata to serve notice on both of the contemnars, and directing them, contemnars, and informing them that they should be present before this court on the next hearing date. List the matter on so and so day.
Obliged.
This particular among six. Ask him to come forward.
Oh. Who is he?
New faces.
Who is he?
One of the contender who has affixed and has.
No, they have been discharged. What is his name? Abhishek Manna.
He is among those six who has filed this
He is
affidavit.
a law clerk.
We have already discharged him.
So
that means.
No, in this statement it is there.
But the Dipnil Banerjee has stated that he temporarily works for him as law clerk.
Abhishek Manna, we won't discharge.
Things are being camouflaged.
Not
It has been
registered,
said
but
that they are
he has,
and
he is in know of the facts in the High Court.
Yes.
So we are not discharging him.
Abhishek Manna.
Except Abhishek Manna. Except
Except Abhishek Manna. So in this, we will implead them. So he will continue to remain. In this, Dipnil will be impleaded, and only Dipnil notice will be served.
Let ask him to be present here, and he should tell the truth about Dipnil Banerjee, because record is there. Statement of Dipnil Banerjee is there under section 161 CRPC, implicating
His
him.
name is dropped as a clerk.
Yes. Well,
He is the law clerk.
who is the name?
Odd jobs scoring. Let him, please advise him later. Let him tell the truth. Let him tell
Let
the
him file an affidavit. Affidavit will make the truth come out.
to appear in person. Abhishek Manna, who has been stated to be the law clerk of Mr. Dipnil Banerjee, has already been impleaded as a contemptor, along with 5 others, for having affixed the posters. So far as the 5 persons, affidavit of apology has been tendered, and the affidavit of apology, unconditional apology, was accepted, and they were discharged. Though Abhishek Manna had also filed an affidavit of unconditional apology, in the light of the fact that Mr. Dipnil Banerjee states that he is the law clerk of that he is his law clerk, for the present his affidavit is not taken on, is not accepted, and it shall be kept pending, and a decision will be taken on the next hearing date. The Commissioner of Police shall ensure that Mr. Dipnil Banerjee appears before this court on the next hearing date, and Mr. Abhishek Manna shall also appear before this.
And one more thing, that so far the discharge of 6 lawyers is concerned, we have nothing to say.
9.
9. The only thing that they should file an affidavit disclosing at whose instance they have done so.
That we will get it. We will get it. That's what Lordship saying from the beginning. And which I think, I don't know whether Commissioner of Police will be able to do it.
And
Mister, there is a problem. Your submission is justified and logical also. but we are also conscious of the problem they may face. Because you know, it is not the old Calcutta High Court bar now.
Yes.
And here the brotherhood is more on political basis than on practice basis.
During last 5 years, madam, it has not.
So might be somebody might have instigated them, abated them. They may, if they take their name, it may be counterproductive for them. They have come forward, they have stated that yes, they went there, agitated for some time and dispersed. But forcing them to again, I do not think it will be justified. Though your submission is justified.
You see, this process of investigation and identification, unless there
We
is
shall find out
cooperation,
other way. We shall find out other way to.
unless
fix
there is
the-
cooperation of the bar with us, will become an unending process.
Yes.
Do not think that by investigation, identification, punishment, we increase the dignity.
Everybody know who
Yes,
these
yes.
persons
Madam,
are.
I had madam, the
You do not think by that we increase the dignity of the bar. The more we protract this proceeding, we lower our dignity.
Yes.
So we need somebody of standing, of integrity and enjoying respect of the bar to come and stand up and say, what has been done is deplorable. I tender an unqualified apology for all my fellow members. This will not be repeated and we shall always maintain the dignity of the bar in future. I think this will put an end to this proceeding
Yes, yes.
earlier than in the way it is proceeding. It is a never-ending proceeding. This identification will never stop. One will say A has done it, A will say at the instance of B, B will say at the instance of C, and this will go on
Yes,
for
go on.
months and weeks. Please think about it.
And
Some leader of the bar has to come forward and put an end to it without any partisan interest on the next occasion. We would expect.
yes, we
those
can.
9 persons all are junior advocates.
That's the point, madam.
And
And on that particular date, I had madam 10:30 fixed matter.
is to honor.
I was restrained by this people.
On their shoulder.
Actually,
No.
Another issue. With regarding holidays on 1st of May. Lordship, remember, I have given a letter to his lordship.
First of May holiday.
At the time when it is being taken up. Now, Lord, deciding this posters issue. Now, my lord, some advocates belongs to some party, my lord. This poster in and around entire high court premises, and some posters are still there. I have shown to his lordship and lordship has told me.
This posters has nothing to do with this proceedings, madam.
My lord, yes.
Wait. No, I think we had passed an order prohibiting posters of any kind.
No poster.
That relate.
No, this poster culture should end, sir.
Yes.
Then we'll do one thing. We'll issue a direction. Tomorrow in your house, inside, outside, we'll paste posters. If anybody who's supporting posters, in fact, you go to the city civil court area, all unions, election, this, that. It took almost 6 hours for the PWD to clean the wall. And they put granite on that wall, complete defacement. Is it not a shame? I was telling your secretary the other day, some fellow is using a stove and making samosas and kachoris in front of the bar association. What happens if one spark comes out? And you are all witnessing this. Are you not witnessing this?
Yes, most
Has anybody raised a voice? You should be proud
should.
of these institutions.
We should.
You should be jealously proud of the institution. No, we will issue notice on that. On what date it was posted?
That error some date.
No, it can't be.
There should, we organize a different program. Like. Now, among us.
That is not. Wait. No, your friend wants to say that you earmark one poster corner, all of it. Shameful. We cannot be asked to.
No, my lord, because he is instrumental of all this. posters.
No, wait. If you want to, there is a program to be conducted, there is a notice board.
Yes.
In the notice board, suppose Bar Association has got a notice board, Bar Library Club, Then you take the information to the secretary. He will initial it to NB. That's the procedure.
That
That's
is
how
related to bar only, not political party.
not political party. This is all unpardonable, sir.
That's fine. Follow.
We left out of the politics part.
The secretary of the Bar Association has
Let him file a petition along with. Let him file a petition along with.
he gave me a letter.
That letter. we
The
can get-
secretary of the Bar Association had addressed a letter to the Chief Justice dated 1/5/2023, stating that certain members of the bar were demanding a holiday on, this copy is there in the lordship, demanding a holiday on 1st of May 2023. When the letter was handed over to me, I had made the following endorsement within parentheses. This concerns the affixing of posters in the High Court campus, full stop. Similar issues being dealt with by the Honorable Larger Bench in CRL CP 1 of 2023, full stop. This letter of Secretary Bar Association be placed before the larger bench after circulating it to Honorable Justice IP Mukherjee and Honorable Justice CR Das, signed 1/5/2023, inverted comma closed. At this juncture, we need to point out that at the earliest point of time, when this contempt petition was heard, by order dated
January 2nd.
The 17th of January. Journal page 10.
17th of January.
By order dated 17th of January 2023, this court directed that no meetings, processions, agitations shall be held or placards shall be displayed within the premises of this court or anywhere else concerning the subject issue, and this direction shall be given due publicity by the Registrar General by intimating the three wings of the bar, as well as displaying the same in the notice board and also posting the same in the official website of the High Court.
Subject issue.
It needs to be pointed out that the members of the legal profession are stated to be members of a noble profession, and the presence of the High Court needs to be preserved, protected, and revered. It is unfortunate that posters had been displayed in the campus in, this is Bengali, no? In Bengali language, demanding a holiday on 1st May 2023. To be noted that prior to the calendar being finalized, the calendar is circulated to the three wings of the bar, and their views are ascertained, and thereafter the full court approves the calendar. Therefore, the full stop. The persons who are engaged, who are instrumental in affixing these posters, if they are members of the bar, they ought to have been aware of this established practice. Since the posters had been affixed in utter violation and derogation of the order and direction issued by this court, we direct the Commissioner of Police, Kolkata, to identify and report as to